And we are good. We are live. So Ed, you can welcome the committee.
Welcome everybody. I am your chairman, Ed Lear, and I was present for our first meeting. Second meeting, I was in a trial, a 3-week trial downtown at Stanley Mosque. And what was interesting about that is that in the largest courthouse in America, there were only 2 trials. And so I do apologize for missing, but it was good to be back in an actual courtroom and not a virtual courtroom. And I think it had been probably 15 months since I'd been in a court. So it was great. So here I am. I'm your chair. And for those of you that don't recall, the relevance of my background is that part of my practice is representing lawyers before the State Bar of California. And so in that regard, I think Ellen and I are rare in this group in having that background and that experience. So that's part of what we'll bring to the table. Ellen is Ellen with us? I can't tell on my screen. Oh, great, Ellen's with us. So Ellen is a presenter today as well on a couple of different topics. And what we had just discussed prior to everyone else joining is that to the extent that Ellen is not back in time for the afternoon session in her portion, then I will jump in until she arrives so that we won't have a 3-hour lunch break, in other words. I understand and appreciate that everyone is giving their time as volunteers on this committee, and we appreciate that, and we're not going to extend it beyond the time that it needs to be extended. All right, so with all that said, Justin, will you please take roll?
Sure. Karen Bell.
Here.
Okay. Ruben Duran, he said he was going to be late. Gary Farwell.
Here.
Jenna Jones.
Here.
Melanie Lawrence.
Here.
Alexia Mayorga.
Here.
Steve Moab.
Here.
Cynthia Nikeo.
Here.
Ellen Pansky.
Here.
Eloise Rosenblatt. Linda Schneider.
I'm here.
Sean Salee. Brandon Stallings.
Here.
Judge Wang.
Good morning.
And our chair, Ed Lear. We have a quorum.
Terrific.
Justin,
And
sorry to interrupt. It looks like Eloise Rosenblatt is in the list of attendees. We may want to promote her to panelist.
Thank you.
and for everybody, I think a good protocol here is to be on mute unless you have something to say, and then you can just hit your microphone.
Okay.
Okay.
I see Eloise now. I will mark her as here.
Good morning.
And Justin, can you make a request for public comment, please?
Yes, if there's anyone in the public attending that would like to make a comment, could you raise your hand now? There looks to be one member of the public who would like to make a comment. Michael Barth, you can unmute yourself now and we'll hold the public comment to 3 minutes.
Thank you, members of the committee. My name is Michael Barth, staff attorney with Public Counsel. Our overall opinion is that we feel conflicted about this move with paraprofessionals because we believe the underlying premise for the program is flawed. Nevertheless, we feel compelled to provide these comments to make sure that robust consumer protections are implemented in any program that ends up being developed. First of all,
yes. The paraprofessional meeting is a different meeting than this, and I just don't want you to miss that meeting if that's what you were trying to comment on.
Is this the Commission on Discipline Committee?
Yeah, this is the effectiveness subcommittee. There's also a paraprofessional meeting that's going at the exact same time. And so I just didn't want you to miss that meeting if that's where your public comment was intended.
Okay, thank you for that. Yeah.
Yeah,
I'll
it's
take
typical
that.
also for comments to be limited to items that are on the agenda, and we don't have anything related to paraprofessionals on our agenda.
Okay, I apologize for the mix-up. Thank you.
Okay, Justin, any other members of the public that would like to make a comment?
It does not appear to be.
Great. Okay, let's roll to the PowerPoints, and which talks about the overall goals of our committee. Go ahead and roll. All right. So this is a short PowerPoint. It's really only 4 slides, but the point of it is just to give a visual to everybody as to what we have accomplished thus far and what our goals are on a future going basis. So in short, we have a charter, and the commission in general is to take inventory of the changes that have been proposed and implemented by OCTC since 2016 and evaluate their impact on public protection. So as I understand the last meeting, that's part of the process that has already begun insofar as evaluating what type of different initiatives and policies OCTC has implemented, and then to evaluate. And then for our group, generally, we will be looking to see whether those policies have been effectively implemented and whether they make sense, frankly. And so in that regard as well, we will be reviewing the full catalog of reforms that OCTC has implemented and identify one or more sets of processes, policies, and procedures to focus on. Also, we will evaluate if these processes, policies, and procedures have had their intended effects, and then based on this evaluation, recommend additional or revised reforms. So that's a big picture view of what this group will be doing. And Ellen and I have been in this world for a long time, along with the members of OCTC. So we may tend to lapse into acronyms. For instance, OCTC, Office of Chief Trial Counsel. So to the extent that we are using acronyms, and there are a lot of acronyms in this area of the law, and if you don't understand them, it'd be good for you to jump in, raise your hands, or I guess use a chat box and just ask about what the acronym is so we don't lose you. And we all collectively apologize for using acronyms. We will try not to, but I think it will lapse into comments that we make. With respect to what has happened and just been discussed so far, there's been a discussion regarding the case processing in the state bar court system and in OCTC. And in that regard, we've heard discussion about the case prioritization system. We have heard discussion about changes in OCTC supervisors, teams, and administrative functions. We've also heard about the modernized case management system that is used internally at OCTC. And we have heard as well about policies and procedures that improve efficiency. There has been discussion in terms of metrics and statistics regarding recidivism. And also we have seen discipline system metrics, which I think we will probably see throughout, because they will really be drivers of the discussions that we have in order to evaluate whether the policies and the procedures are working effectively. Next slide, please. Today, we will be hearing about the California state audit, and Dad will be presenting about that. We will also be hearing about case processing, including standardization and consistency. And you've already had a little bit of a preview about case processing, I think from Melanie and from Steve. in terms of the goals that they have in their office. And then you will probably hear more from Ellen and from me, and from others as well, about how we think that's working and how it could be more effective. And I think those are really important issues for this committee. I keep forgetting Judge Wang on this. Judge Wang is very important to give the judicial perspective on these things like standardization and consistency from her point of view, which is the point of view of somebody who is seeing this from the bench. And also, we will touch upon today and then continue into July, factors impacting case settlement. And I in particular will be very interested to hear Judge Wang's comments in that regard, because she looks at this from a different perspective. And particularly in terms of case settlement, she's got no skin in the fight and sees it maybe from a filter and a lens that is different than that from OCTC and the State Bar. We will be looking at the review of discipline standards and the need for greater flexibility. We will hear about early neutral evaluation conferences, and I'll just jump in. You're going to hear the term ENEC a lot in that discussion. And the ENEC is somewhat of a fancy term for a settlement conference with a judge, with a State Bar Court judge, that occurs prior to the filing of a notice of disciplinary charges. And it's a really effective tool. And it gives us the ability to do, amongst other things, non-public discipline, in particular in the case of private reprovals, which is a very low level of discipline. The private reproval is something that can truly be private through an early neutral evaluation conference versus a private reproval that is negotiated after the filing of charges. That is a private approval with public disclosure, and matters a lot to lawyers because that is something that the public becomes aware of. And so important distinction, and we'll get into that as well. Stipulations are the written documents that are entered into in order to effect a settlement. Moral turpitude is a big topic in State Bar discipline. It's defined by either gross negligence or dishonest or corrupt acts. And from a defense lawyer's point of view, moral turpitude is just a kiss of death, because it's something that hangs with you on your membership record for the rest of your career. And so a lot of times these cases that are settleable may not settle because of the difference that defense has with OCTC concerning moral turpitude. And it's the type of thing that will push a respondent to go to trial in order to try to fight the moral turpitude charge. Next slide, please. In July, the focus will be on the prevention, support, resources, and mandated training for populations. In particular, solo practitioners, aging attorneys, which I think is a really interesting topic, because the aging attorneys are ones that probably the metrics will show, to the extent they continue practicing, probably have a higher degree of discipline per their age group than others. And I don't know that that's necessarily true, but I'm as interested as anybody with that. Attorneys with substance abuse problems, that is a challenge, not just for attorneys, but for any licensee and for individuals in general. Diversion, I think the way that that's being used here is to describe the alternative discipline program. For those of you that have done medical board work or have any experience or knowledge of the medical board, the term diversion program probably really started there, where doctors who had substance abuse or mental health challenges were often given the opportunity to go into a diversion program. I know they did that with nurses as well. So the program for attorneys that is probably, I don't know, 10, 15 years old at this point, is called Alternative Discipline Program. And it's a really interesting one. And it is just an awesome thing that the bar has done to allow attorneys to recover and become good members of the profession once again. In August, we will also be talking about metrics, and that term keeps coming up because, as I think, and probably most of you agree, metrics will really inform us as to the effectiveness or not of different bar programs. And so in that regard, it'll be important for us to learn what the numbers say, what the statistics say, in order to get a better handle on where problems lie and or where there have been problems, where different policies that have been implemented have changed the metrics in a positive way. And I suppose it could also be in a worse way. I think that's our last slide. Is that right?
Yeah.
Okay, good. So that's the meeting agenda. With that, actually, before I go any further, does anybody have any questions or comments regarding the slideshow? Seeing none, I really expected Ellen to jump in and correct something I said, but good for me. Okay, so, and I meant that in a good way, Ellen. So let's see, let's go to Dak, who will be giving us an overview of the 2020 California State Auditor Report.
Thank you, Chair Lear. I'm going to start with the overview of the 2020 California State Auditor Report. It was actually released just this last April, so it covered the previous year and actually the previous number of years, but it was just released. And I'm going to go over the audit process, discuss the findings of the audit, and then discuss the State Bar's response to the audit. I did want to make a quick procedural note regarding something that Chair Lear said regarding using the chat. We made good use of it at the subcommittee on fairness on Tuesday. And when I saw that, I immediately asked our staff to disable the chat function. I apologize. It's not ideal, but we have been hacked in public meetings through the chat function. And so as a safety protocol for security of our meetings, we have sort of a standard protocol for disabling the chat function. So if you do have a question, please don't hesitate to just unmute yourself and interrupt me. I'm happy to deal with it the old-fashioned way. So if we could move to the next slide, please. Just to provide a little bit of background on the audits, Business and Professions Code 6145B requires that every 2 years, the board contract with the California State Auditor's Office to conduct a performance audit of State Bar operations. This statute is constructed pretty broadly. It allows the California State Auditor wide latitude to evaluate whatever aspect of State Bar operations the auditor thinks should be audited and look into our operations. The 2021 audit focused on, among other things, and the key issue of relevance to this group is it focused on changes to the discipline system and their impact on the efficiency of the discipline system. So obviously, very relevant topic to the subcommittee on the efficiency and effectiveness of the discipline system. So looking at the audit findings, if we could move to the next slide, please. So the focus ostensibly was the focus of the audit in terms of the efficiency of the discipline system was the reorganization of OCTC following recommendations of the 2016 study on workforce planning. And this too requires just a tiny bit of background. So in 2015, the California State Legislature imposed a mandate on the California State Bar requiring that we engage in a process of workforce planning and that we produce recommendations for reorganization of the State Bar that would improve the functioning of the State Bar. And so between roughly the November-ish of 2015 2015 and April of 2016, when the State Bar issued this what we refer to as the workforce planning report. We worked with a contractor who did a real sort of top to bottom evaluation of State Bar operations, including a fairly extensive evaluation of the work in the Office of Chief Trial Counsel to come up with recommendations for changes to operations, reorganization recommendations, among other things. And I had a screen. This is it. Here it is. So I was just looking at a 2017 report that was submitted to the Board of Trustees, sort of reviewing the recommendations for Office of Chief Trial Counsel, and let me say also that the focus of the recommendations today and the focus of the state auditor is really OCTC, even though we oftentimes talk about the discipline system broadly, when really what we're talking about is OCTC. So the California state auditor, similarly, in focusing on the discipline system, really focused on OCTC. But the workforce planning recommendations for OCTC, there were 17 of these recommendations, and they were fairly substantial recommendations, many of which were implemented. I'm just going to read a couple to you. We eliminated separate intake and enforcement units. So this was sort of in the weeds case processing issue with regard to how cases flow from the initial intake phase into an investigation phase when a case is deemed appropriate for investigation. A recommendation came about creating supervisory attorneys, a supervisory class of attorneys who would lead teams and have authority over an entire team of attorneys, investigators, and support staff. There were recommendations related to the scope of authority of supervising attorneys and empowering them to exercise discretion at the level of the team, so that we didn't have as many layers of review and oversight that were to slow down sort of case processing. I could go on, but I won't. I just wanted to give you a little bit of flavor of the workforce planning recommendations as they related to OCTC, and many of which were either implemented in full or substantially implemented. So this was really the focus of the auditor's most recent report on the efficiency of the quote unquote discipline system, but really on the efficiency of OCTC, what it was looking at. And so if we move to the next slide, I'm going to talk a little bit about sort of the main findings of the auditor. It was not a positive audit. It attributed a great deal of what it found were problems. It attributed those to the reorganization and the reorganization from the workforce planning recommendations. It attributed these negative findings to that reorganization. So in one example, it looked at an increase in backlog over time in the Office of Chief Trial Counsel. And this is taken directly from the audit report, this graph, and it said, look, there's this big increase over time. If you take the lowest point, the point at which backlog was its lowest, and then you look at where it would stand in June of 2020. It's actually a point in time we never use because that's not what we're required to look at in terms of our backlog. We're required to report it in December of each year. But regardless, it looked at this and it said, well, that's because of the reorganization. Next slide, please. So it also looked at the amount of time that cases spent in investigations. And it said, oh, the amount of time that cases have spent in investigation has increased. And it attributed that to the reorganization. Before going to the next slide, what I'd also like to note here, though, is that this struck us. I'm going to make a more comprehensive response to the audit findings in a moment. But before I do that, I just want to note that it struck us as a bit odd to take a phase of case processing, the investigations phase, look at how long a case took in moving into investigations and then out of investigation, and then isolating that and saying, well, this is a problem, because there's a case that comes before OCTC in intake. We initiate a new case, And then eventually it is either filed with the State Bar Court, or it is closed, or there are a number of other outcomes. But isolating the investigations phase, to our mind, didn't make a lot of sense, because it's not really looking at the full picture of how long case processing takes. Another issue related to this particular number has to do with looking at the amount of time it takes to quote unquote close a case, and that would include moving a case beyond the investigation phase, but that's what they're measuring. And if you're closing older cases, which could be a good thing because you're getting rid of maybe older cases from your inventory, by doing that good thing, what you have is this unexpected outcome that your case processing times increase, because you're adding older cases into the mix of cases from which you're calculating this number of, like, the average number of days that it takes to get a case out of intake. So we found this number problematic, but this was part of the audit's findings. And then the final item that I'm going to reference in terms of the audit findings is on the next slide. And the California State Auditor expressed their concerns about a decline in the percent of cases closed with discipline imposed. This is one of the areas where the state auditor did not explicitly attribute this to reorganization, but it asserted that it's a problem. And I think that our response to this is that we're not sure that it is a problem. We looked at data over a much longer period of time and actually found we did a look back and presented this data in the 2020 annual discipline report, and consistent with the date issues, the 2020 annual discipline report is published in 2021. It's the report that we produce in April. But we did a 20-year look back and actually found that there was a bit of an increase in discipline around the early 2010s, and it appears to perhaps have been driven by the loan modification, the big number of cases that came in under loan modification discipline related issues. And we saw an uptick in discipline around that period of time, and immediately following the big numbers of loan modification cases that came into the discipline system. And then we saw a decline, which kind of looks like it's returning to something more like a historical normal level of discipline imposed. But we didn't view this as especially problematic. And although I think it's too early to say that efforts that we've begun to make in the direction of proactive risk-based regulation and preventative types of programs, it's too early to say really that those are taking effect, but that would ultimately be our goal. I think that we don't think that imposing discipline is necessarily the best measure of protecting the public, but this was an issue that the audit raised concerns about. So now I'm going to speak maybe a little more globally to our response to the audit. On the next slide, I would say that my main concern about the way that the auditor framed its statements about efficiency and effectiveness of OCTC's work, my main concern is that it appeared to be pretty reductionist. In many cases, the auditor looked at the changes that occurred in 2016 as a result of workforce planning, and then attributed everything that it saw to those changes. That somehow the reorganization in Office of Chief Trial Counsel was really that was what is responsible for any changes that you see subsequent to that. Well, to look at just a couple of other issues that are pretty significant changes in the Office of Chief Trial Counsel, and I think are impossible to really isolate from other changes, in particular the workforce planning changes, is that an entirely new case management system was implemented. That's the Odyssey bullet. That's what we call the case management system. That's the name of the case management system that's now used in the Chief Trial Counsel's office. That is a major initiative that not only involved, it's not just the switching over to a new technology. It's actually the staff time uh, in implementing that's involved in taking staff off of the line and getting them involved in review sessions with the implementation team to evaluate, like, well, how are you going to use this new case management system? Where does data go? What does case flow look like in the new case management system? So this is a significant event in terms of the Office of Chief Trial Counsel that it occurred over 2 years during this period following workforce planning. Similarly, case prioritization has been introduced into the Office of Chief Trial Counsel, and we are increasingly focused less on the overall backlog and more on the backlog of priority 1 cases, those cases where we think there's the most potential for significant harm to the public. And then COVID-19 happened, and we were in fact in the middle of the lockdown related to the COVID-19 pandemic when the state auditor was doing their work. And apart from any other impact of COVID-19 related to scheduling of hearings or remote work that's being done, really having all of OCTC's staff off-site and working remotely for the first time ever is a pretty significant issue. And yet you will not see in the California State Auditor's report any reference at all to COVID-19, except where it talked about the California bar exam. So none of these issues, to my mind, were really given appropriate consideration in the state auditor's work. And again, I used the word reductionist earlier. I really did believe that the auditor seems to want to tie everything to the workforce planning efforts of 2016 and then say anything that followed that was the result of that. The other issue that I want to focus on, though, in terms of the State Bar's response to the audit is sort of what seemed to me to be a disinterest in the data that we've been generating to track the work of the State Bar. And I've got a couple slides that will show that. On the next slide, one of the things that we have developed as a tool for tracking our work and trying to evaluate where we are and where we're headed is looking at caseload clearance. And this is it's a relatively simple metric, and it simply allows you to say, okay, for every case that comes in the door over a given period of time, how many are we moving along and getting out the door? So caseload clearance is a pretty widely accepted measure. It doesn't capture everything, but it captures some important information regarding whether you're going to start to get yourself really underwater with your case inventory, because if you're not moving as many cases out as are coming in, then you're going to quickly develop a much larger inventory than you can manage. So what we've seen over the last 3 years is that we've had a steady increase in the percentage of cases that we are moving out among the highest priority cases. That's the middle 3 stack of bars there. The far left bar in black is simply the target. At a minimum, you would want to be moving 100% of cases out. Since we do have a backlog, we're interested in moving more than 100% of cases out. And what you can see is with the highest priority cases, we've consistently moved out more than 100% of cases and are closing them more quickly than they are coming in, or excuse me, closing more of them than come in. And even in the most recent year, we've begun to start moving the lower priority cases as well. So for the 3 years, 2018, 19, and 20, that are shown in the middle stack of bars, those are the highest priority cases. In the most recent year, we closed out 146 cases for every 100 cases, 100 new priority 1 cases that came in. So the auditor wasn't particularly interested in this. The next slide shows another metric that we have developed and that we report in the annual discipline report. This is our effort to say, yes, we know that backlog matters and we are doing what we can to get a handle on it. You'll note also, but we also want to distinguish between the priority 1 cases, the highest priority, and the lower priority cases. So what this graph shows is that the blue portion of these bars, the highest priority cases, is on the bottom there. And over the last 3 years, since case prioritization has been in effect, we've done a good job of decreasing the backlog of the highest priority cases. It's shrunk from almost 600 cases in 2018 to 518 cases in 2019, and further still down to 429 cases in 2020. I would also note that in the total number, the top number on the bar is the 2,547 cases in backlog at the end of 2020. This is slightly lower than what the state auditor reported because, again, they calculated a number for June, which is not a number we ever report. It's not ideal to have a point in time calculation, but that's what we are mandated by statute to report on. And so normally the reporting period is the end of December. It's December 31 of every year that we're required to report on our backlog. And then on the next slide, the final item that I wanted to focus on in terms of our efforts to look at the data and report the data really in a manner that reflects the focus on public protection, which is ultimately the mandate of the state bar, is to protect the public. We have spent some time really combing through the data and looking to distinguish between cases and attorneys, because where we report out data on cases, we're sometimes reporting out not only multiple cases that are associated with a single attorney, because oftentimes the case, which comes in as a complaint, there could be many complaints against a single attorney. It's been our contention for some time that the case as a unit of analysis isn't a good reflection of public protection, because if the attorney is engaging in misconduct and the attorney is either made inactive or is ultimately disbarred, that the decommissioning of that attorney is what ultimately protects the public, not the case. It's not the equivalent would be, say, in the criminal context of focusing on the number of charges against a defendant rather than looking at what happens to the defendant. Is the defendant found innocent, found not guilty, or is the defendant convicted? So this measure, which we've also been reporting in our annual discipline report for a number of years now, simply takes the high priority cases that are in backlog and begins making what we think are important distinctions here between these 429 cases that are the highest priority of cases in backlog, and looking at how many attorneys those cases represent, and also distinguishing between cases that are suspended and cases that are still active cases. And many times cases are suspended because there are multiple cases against the attorney, or there are other reasons why the attorney may not have an active case against him or her, and looking at what we think is the focus of it should be the focus of the state bar, public protection. So out of those 429 highest priority cases in backlog, if you narrow it down to the number of attorneys that those cases represent, we're looking at a much smaller number. And we think that this is important because we've been mandated to report cases, but we think that ultimately it's attorneys, and in particular attorneys who are eligible to practice law, who should be the focus of our public protection efforts. And when you move from that 429 number down to the number of attorneys who are eligible to practice law, you get to a number that's substantially lower. It's barely 150 attorneys among these 429 cases who are still eligible to practice law. So I think that's the last slide that I have. Let me just, yes, it is. So let's open it up for questions and discussion.
Hey, Dag, this is Brandon. Would you or maybe Melanie or Steve address how the backlog metric really drives different decisions that are made within OCTC at various points of the year?
I could take an initial crack at it, or if Steve or Melanie would prefer to jump in. I mean,
Go ahead.
so there's a term in economics called about perverse incentives, where you create a policy of some kind that leads people to behave in a way that doesn't achieve your intended outcomes, and it's that term that I think is applicable to our backlog goals that have often been used as something of a bludgeon to beat the state bar up, in terms of saying, oh, you're not doing a good job because of backlog. We would like to move the cases as quickly as possible, but they need to be moved correctly. They need to be evaluated properly, and the time needs to be devoted to them to ensure that nothing's being missed. So the perverse incentive of the backlog standard is that it, I think, takes the focus away from public protection and focuses people's attention on, well, we got to move cases. And so historically, it was the oldest cases that became the focus of both individual motivation within the office in terms of attorneys and investigators looking at their individual caseload and saying, I got to move my oldest case because my oldest cases are the ones that are falling into backlog, as well as institutional motivation, where managers and supervisors saying, we're going to be reporting a number, we got to get rid of the backlog. And so focusing on these oldest cases rather than on the cases where the most potential harm to the public exists became the motivation, largely as a result of the backlog. I think intense focus on backlog that has been generated by certain mandates imposed on the state bar.
I would just also add that because the backlog is essentially measured at the end of the year, it creates the cyclical kind of work that doesn't actually highlight public protection consistently throughout the year. What ends up happening is that right around the end of June, 1st of July, when you know 180 days ahead what the total amount of cases are going to be in your inventory that you have to work to chip away at before the end of the year, then the staff has had a tendency to over focus then at the end of the year. And what you see is that by end of November and December, we're spending a lot of time in state bar court. State bar court's getting a lot of filings. And then what happens at January is everybody's exhausted. And all of the trials then begin around March and April. So it's really this unhealthy work cycle for the staff. And again, it doesn't prioritize public protection throughout the entirety of the year.
So one of the things we've done to try to remedy that is to really make quarterly goals that work off of either the 180-day backlog or reasonable processing goals for different segments, but to really make that a rolling 180 days or other time goal standard throughout the year, rather than focusing, while we acknowledge that we report based on December 31st, for our internal measures, we are focused on a rolling number throughout the year.
So with this being the effectiveness subcommittee, is there a thought on what metric might be a better reflection of cases in backlog, whether from a timing standpoint or some other metric, something that would communicate to the legislator through the annual defense report or annual discipline report, how we're doing with case inventory, but also having a more realistic metric to communicate that the effectiveness of our discipline system.
I don't know, Dag, do you want to talk about some of the thoughts that we've had about that? I also see that there's a number of hands up as well.
Yeah, I think the one I saw right away was not the blue one. It was Eloise.
Eloise. Yes, Doug, thank you very much for your comments. My immediate response would be, there's a difference between moral turpitude, which would be very serious cases, and problems keeping track of one's IOLTA account, or in the middle area where I've seen disciplinary reports, they have a lot to do with financial mismanagement or taking money and not performing service. So I think maybe if these auditors are interested in the kind of, in the number of cases, that's really not sufficient. I think what would help and honor the work of these Office of Trial Counsel, from what you've said, I mean, you're attending very carefully to the number of cases, but I would parse this out and identify which kinds of cases are you really paying attention to as part of protecting the public. I mean, certainly it's very important to protect the public financially and, clients who invest in attorneys, but, that would be one of my suggestions.
Yeah. Comment?
Ellen, her hand.
So I first want to say, by the way, I was a state bar prosecutor starting in 1978. And I've been consistently practicing before the state bar court for well over 30 years. And so from my anecdotal point of view over many years, I would say that it is true that the Office of the Chief Trial Counsel is doing a good job. They are catching lawyers who engage in misconduct. I've consistently said that over the years. So the idea that we are failing as a profession to protect the public, I think is not correct. And I don't think that the statistics bear that conclusion. The fact of the matter is that year over year, it's the same 5% or less of lawyers who find themselves in the disciplinary system who end up with discipline. And that's not because the prosecutors aren't doing a good job. It's because the vast majority of complaints do not present a disciplinary offense. And I am very pleased to hear Dag say, and the rest of you state bar employees say, that you're looking towards prevention as a goal. I've said this before, and I really would love to see the statistics on recidivism for those lawyers who go through the state bar ethics school programs. Since the state bar instituted ethics school, it has been, I think, wildly successful. Rarely, if ever, have I had a client, a respondent in a state bar proceeding, tell me that they did not find ethics school valuable and helpful. It's a very strong resource that the state bar has, and I'm pleased to say that the state bar uses it more and more frequently. It's almost, I'm going to guess, 95% of cases where the lawyer has engaged in some either disciplinary offense, in which case it's 100%, or something that the state bar determines is more of a negligence type of situation and not a willful disciplinary violation, that the respondent is given the opportunity or required to go to ethics school. So I think that in looking at clearing the backlog and processing cases, I think more attention should be given to the prevention side. I do want to say that from the defense bar's perspective, there is still a problem with the backlog. And I think that it might be helpful for us to carve out some time, not this moment, but to have a separate workforce on looking at ways that OCTC might be able to create another unit, a backlog clearing unit. Just to give you an example, and I've gotten some feedback from people who do state bar defense work, that we are seeing a significant number of cases that we've heard nothing about from OCTC from between 6 months, and in one case I had this month, 16-month delay between the submission of the explanation by the respondent and any response reply at all from OCTC. That's too long. And I think that it would be helpful to create some sort of unit who would intervene in cases where there's that kind of delay. And I think that would be cost effective and probably doable with your existing staff. I also think that I'm not sure, I would like to be more down in the weeds on how these cases get prioritized, because it's not clear anecdotally whether it's true that the more serious cases are getting processed more quickly. I think there's something going on there that needs to be addressed. Anyway, so without going through, specific examples, I do think that it would be very helpful to get the defense bar's input, and Ed and I probably can make some more additional specific concrete recommendations of ways that we might help you clear the backlog.
It looks like Karen Bell has her hand up.
Thanks. Yeah, I wanted to, I guess, kind of echo a couple of things that both Eloise and Alan noted, but I mean, it seems to state the obvious, the most important statistic is the number of complaints, right? Like if we decrease that, then we're protecting the public, unless we're doing something that's prohibiting people from complaining. But assuming we're not doing that, then that's clearly the goal. So, backlog isn't really it, right? It's about that there's less reason for discipline, and that does obviously, relate to the recidivism question too. So I guess I was wondering is, and certainly agreeing to track by the type of cases, and along those lines, I'm wondering, since so much of it does seem to be financial, and I don't know what the percentage is, but since it seems to be a fairly high percentage, and I was wondering if we could even, dig deeper into that. Like, what are the nature of those financial issues? Is it more about like damages and awards, and that the, attorneys messing up with those, or retainers, or what is it that they're doing? And is there anything, in addition to the ethics school, which is great, is there anything else that could be done to protect the public on the financial side? Is there anything that other states are doing to protect the public on the financial side? I mean, I don't know. And that's less about discipline than sort of getting to the root of the problem, and sort of repairing and preventing the harm in the first place, and maybe repairing it. I don't know the answers to these questions, but it seems worth asking. And then on the ethics school piece, since that does seem to be working so well, it sort of begs a question of, well, should more people be doing that on a prevention side? Like, why wait until you get in trouble? Like, should we be requiring that? Why is the ethics requirement for MCLE so small? And you don't know what you don't know. You don't even know what ethics classes to sign up for, because you don't know where you're going to get in trouble. So why are we doing such a poor job of educating people on the ethics requirements? And, it's been a long time since I've taken the ethics exam and been in law school, and I don't remember all that stuff. It just seems like there's a lot more, and I know I'm a broken record on the prevention side, but I just think it's so critical. And so I don't know if there's any responses to any of what I just asked or said, but I'd love to hear it. Thank you.
Ellen, did you raise your hand again? And then Chairman Lear.
I think Ed was first. Go ahead, Ed.
Yeah, Karen, I think you had some really good comments, and this is something that that I pitch to an awful lot of my lawyer clients, which is when they roll their eyes about the ethics school that is a requirement for discipline. My response is always, not only should they go, but that virtually every client of mine that's ever gone to ethics school has thought it was a positive, good experience. And I go one step further, and this is a personal comment, but not a bad comment. Maybe Karen shares it, which is every lawyer in California should be required to go to ethics school. The state bar does a very, very good job with ethics school. And most of the time, the feedback that I get is, I learned so many things that I didn't know. And that somewhat gets to the heart of the problem. Sure, we have MCLE requirements, do your 25 hours in 3 years, and there's an ethics component that is included there, but that doesn't necessarily cover the ethics issues that are covered in ethics school. The other comment that I have, and this is maybe even more to Karen's point, which is there's also client trust accounting school. So if you have a discipline as a result of a client trust account violation, you have to go to client trust accounting school. And it's on a Saturday, and now apparently you can do it remotely, and I hope that continues. But that's, again, same type of feedback. Wow, learn things I didn't know. And of course that catches my attention, which is that's probably why you are disciplined in the first place when you're not paying enough attention. But again, something where we could consider that being a requirement for all attorneys. And there's a huge burden on the state bar to do something like that. I get it. But it's something that where we would potentially evaluate the benefit of educating everybody through these really fantastic programs that the bar puts on in an effort to avoid and prevent, which is Karen's point. That's it.
I just wanted to add that I attended most of the Fairness Subcommittee meeting on Tuesday, and Ed and I are alternating to try to cover that committee as well. And a major part of the presentation at that committee was about what's called reportable actions or reportable bank actions, where if there's any type of anomaly in the lawyer's trust account, then the banks are statutorily required to report that to the state bar, and the state bar investigates those. And in that discussion, a couple of things came to light. One is that a tiny percentage, less than 3%, I think, of lawyers who have those kind of problems end up with discipline, because they are in fact caused more by office bookkeeping problems, negligence, errors, that sort of thing. But it was interesting to me, and I think it was Jerry Larkin, who's been long affiliated with the Illinois bar, who said that in Illinois, anytime a lawyer opens up a client trust account, they're required to go to trust account school. And that Illinois does not treat these types of violations of the trust account handling as a disciplinary offense, unless, of course, it is shown that the lawyer is misappropriating client funds, which again is a infinitesimally small number of cases. Usually that is not the problem. So I hope that we, as our two subcommittees together, can coordinate. I know that the Fairness Committee is looking at that.
Looks like Judge Wang has her hand up.
Thank you, Justin. Can I ask perhaps Melanie or Stephen to clarify this? I know we talked about this at the first group meeting about OCTC's prioritization setup, P1 through P3. I think that kind of folds into what Dag is talking about backlog.
Sure. So we have identified certain cases where at the earliest possible time, we prioritize them as P1. Those are the cases that pose the most serious public protection risk. And the idea is that staff resources will focus on those first and do what they can to move those cases along before the P3 cases, which is the P3 cases are oftentimes, without going too far into the weeds on the prioritization system, many of the other cases that are going to take at least some time. So, but just to give you an example of P1 cases, for example, would be cases in which there are vulnerable victims. So a criminal defendant, for example, or an immigrant, an elderly person. Also cases where the allegations suggest that there's a misappropriation of a significant amount of money and the money has not been repaid. So there are a number of those kind of categories. And when Steve mentioned our quarterly goals, we actually focus our quarterly goals to try and move those cases along quicker, both in the investigation phase and then if they move into the pre-filing phase, to actually move those cases faster to filing, to either settlement or notice of disciplinary charges. It necessarily means that the cases that are in the P3 inventory are going to take longer because we're not devoting our resources as significantly there. That, when we've talked about the backlog and the backlog rising, the backlog has risen most significantly in those P3 cases, and that's what we would expect to happen if we were prioritizing other cases. Does that answer your question?
And in fact, the backlog of P1 cases has been reduced year over year consistently.
I will just add something, especially since Judge Wang, you were the one that asked the question. What's interesting is that while OCTC prioritizes certain cases, once they're filed in state bar court, I'm not sure that there are similar prioritization that happens. I know that there are time standards that the court has, but I'm not sure that they're focused on particular cases or not.
Well, just to let everyone know, when Melanie's referring to the timeline, under the rules, we are supposed to set the trial within 125 days. So it's fairly fast tracked. So when we're talking about, effectiveness, the question is, I don't know if that's something that this committee wants to take a look at. And some of the frustration I think the judges have is we have to fit everything into a timeline. So you may have a very complicated, I have several sets of 2-set respondent cases, or, where matters are joined and it's going to take days, if not weeks, but that is given the same priority as a 1-count probation violation case. And so I don't know if that is, a lot of the pressure also is, and Melanie and Steve can talk about this as well. There's a limitations period. So there's generally speaking, unless there's an independent source and there's some tolling exceptions, it's a 5-year statute. So there's a lot of pressures going on at the same time. So to directly answer Melanie's question, we have to find good cause if we set a date beyond 125 days. So the closure rate is pretty tight.
Don't see any,
Raised hands?
I don't see any other raised hands.
Okay, good. So thank you, everybody, for your comments. Let's move on to the next agenda item, which is case processing, standardization, and consistency. And Chris Jagger will lead, and he's from the calibration team, and then Ellen will respond with the ADDC viewpoint.
Okay, good morning, everyone. I'm Chris Jaggard, one of the assistant chief trial counsels. I'm in the San Francisco office. Yeah, you can go to the next slide, is fine. Thanks. So this is just a quick overview. We have approximately 90 attorneys. This fluctuates a little bit, but approximately 90 attorneys in OCTC, and that's, you can see on the slide, 15 or so supervising attorneys. This also fluctuates a little bit, but not much. And you can see the different teams and how it's broken out. We have 5 assistant chief trial counsels. As I mentioned, one of my responsibilities is calibration. That's what I'm going to talk about today. So I think we can go on to the next slide. So why calibration? So I'll start with just a little bit of a brief history. Our current calibration unit was the result of the workforce planning study. I think it was carried out approximately in 2016 or so. And I think it was likely based on a combination of some of the recommendations there. And that was, one of them was to eliminate most complaint type enforcement teams. So for example, I think the office used to have like a major misappropriation team, for example. They would handle only those types of cases. And so we've replaced that with more generic trial teams. And those trial teams are led by a supervising attorney. They have attorneys, investigators, paralegals, legal secretaries, and investigative secretaries on those teams. And they handle pretty much any type of case. So it's no longer specific to any, the teams handle whatever comes in the door. So they're all handling similar cases. And there's 8 or 9 trial teams in Los Angeles, for example, 2 or 3 in San Francisco, as well as we have intake teams and on an UPL, or unauthorized practice of law team, which is I think the exception, of a more specific team. The second recommendation was to establish a supervising attorney position that's responsible for team supervision. And with that, empowering those supervising attorneys with decision-making authority, which means that unlike before, now the level of discipline decisions are not made or approved by the assistant chief trial counsels. They're made at the supervising attorney level. And therefore, because of the more decentralized decision-making authority that was given to the supervising attorneys, OCTC had to work on a way to calibrate the outcomes. So a little bit further background before I get into the tools that we're using to calibrate. I believe a few years back, some state bar committees reviewed the discipline standards and considered making them more rigid with less discretion. But instead, they actually left them very broad with large ranges. So for example, actual suspension to disbarment for certain offenses. And they left it discretionary in terms of analyzing the mitigation and aggravation so that each case could be evaluated individually on their own merit. Now, doing this, however, means that calibration is more difficult because each case, for example, where there's a misappropriation, has different mitigation, it has different aggravation, and there's wide ranges of discipline that are applicable. So there may be a perception sometimes that there is inconsistency and therefore a need for better calibration, but there could be valid reasons for the level of discipline being different in those cases. Another example is 2 DUI type of C cases that we prosecute. There could be vastly different outcomes based on the facts and circumstances, and it has nothing to do with calibration. So there's this tension that we have between the potential, I think, unfairness caused by the drive for this rigorous consistency. That is, quote unquote, we want calibration, but the cost is that every case of misappropriation would result in the same level of discipline if we don't look at the individual case, individually. And then on the flip side of that, there's the potential for unfairness caused by too much discretion where there is an actual need for better calibration. So in terms of how calibration currently works, I have a list, which we're going to get to in a minute. I have a list of various tools that OCTC uses, and I'll go through each one to explain. And then at the end or during the presentation, you can ask questions if you have them about in more detail about what they are. My team works together with the SAs, the supervising attorneys, the assistant chief trial counsels, and of course the chief to ensure that we're calibrated on charging, level of discipline, and stipulation resolutions. In terms of how before we get into the details of each one, in terms of how we're doing, I think we're doing well, and many of the tools that we're using are working. Some of them have been more recently employed, but we have challenges. There's 90 attorneys in the office, including the chief, and so there's definitely room to grow in this area, and we're constantly looking at areas that we can improve in. So our biggest challenge is obviously making sure the supervising attorneys are calibrated, and that's because the vast majority of the office's decisions are made at that level, and we have 15 different individuals or so performing those jobs, and I'll get into the details of how they do that in a minute. But so a lot of the tools that we use are geared at the supervising attorneys, making sure they're all on the same page. Obviously, we're not 100% aligned in our views. You have different people making these decisions, but we're aware of the decisions that come out. We discuss them as you'll see through our various tools that we're using, and we're constantly working toward calibrating the different teams in the office. And so in terms of what is decentralized, key issue is approval of charging memos and draft NDCs, notice of disciplinary complaints, by the supervising attorneys. And those decisions are made by the individual SAs, unless it's a major case. And so obviously the SAs use the tools that we have to guide their decision-making. So it's not completely decentralized in that sense. We have policy directives and other things that I'm going to talk about in a minute. But it is probably the most decentralized in terms of our decision-making. And that's the approval of the charging memos and the NDCs. One of the tools that we use, I'm going to talk about in a minute, is the trial team meeting, or TTM for short, we call it. It's mandatory now for certain types of cases. We have one member of my team that handles those, all of the trial team meetings now. So we're able to see globally throughout the office and these are happening before we file now, before we file the charges. So we're able to globally see what's going to be filed in particular cases. And so that's one of the new tools that we're using to help calibrate the office. All right, we got the next slide up. Good. So some of the tools that we're using, I just mentioned the trial team meetings. First up, they've existed in the past, so it's not a brand new concept for OCTC. They have been not quite as centralized as we have them now, and they are now mandatory, as I mentioned, for certain types of cases. So for example, all cases where OCTC is charging a misrepresentation that has to go through a trial team meeting with the attorney on my team. 8.4.1 rule violations, elder abuse related matters, trust related matters. That is, for example, where attorneys are acting as trustees, or where there's a breach of fiduciary duty, where the attorney is acting as a trustee. C cases involving domestic violence in the conviction, or facts and circumstances. Also, C cases involving a DUI related death, and also cases involving an allegation of breach of fiduciary duty. And so those are all mandatory for participation in the trial team meeting before filing charges. And of course, they have the option of requesting a trial team meeting for other cases as well. So, and many do. So we do include other cases, but those are the mandatory types of cases that go through them. And they're attended by the attorney who's prosecuting the case, the supervising attorney, the attorney on my team that leads the discussion, and then typically the assistant chief trial counsel is also invited and usually attends those as well. And so it's a relatively small group, and it's a discussion led about the charges. And then the attorney on my team will give his opinion about the charges and the level of discipline sought in that case. So that's the first tool that we use. And those are held weekly, I mean, as needed. So they're usually every week we've got one or more going on those meetings. The second is a leadership team meeting. The name has changed a little bit over the years, but the current title is leadership team meeting, and that's bi-weekly. That's another tool we use. And this one is fairly critical as well, because the SAs, the supervising attorneys, and the assistant chief trial counsels, as well as the chief, are all in attendance at this meeting. And the supervising attorneys are equally responsible for the agenda. And so it's a chance. It's not limited, obviously, to calibration issues. There's a variety of topics that appear on the agenda. But for example, frequently there are calibration issues discussed on the agenda. Is perhaps charging breach of fiduciary duty type cases. They discuss pleading templates, macros that we use. Sometimes they'll discuss issues with settlement conferences that come up, or how to handle certain types of cases. We've discussed DUI cases, at various times. So it does certainly involve calibration pretty much at every single meeting on some level. And so it's an opportunity for the supervising attorneys to discuss amongst themselves with Melanie in attendance, their views on various issues, and we get a chance to try to get on the same page with everyone so that everyone has the same understanding of where we are as an office on a particular issue. So then the other meeting, I think it's next on the list, is our manager meetings for the assistant chief trial counsels, the chief, and the special assistant. And those are weekly. Now, obviously, of course, it's not limited to calibration issues. We talk about a variety of things, but it is an opportunity that during those meetings, I can give updates on our appellate cases, talk to the managers when I see that perhaps we've gone too far in one direction or another on a particular case that's gone through a trial team meeting. The attorney reports to me after conducting the trial team meeting, and we discuss. And so then I get a chance to bring those issues to the other managers and the chief as well at those meetings. So that is another opportunity that we have to work on calibration in the office. The stipulation calibration meetings down on the list there. Historically, I think the office has done this, maybe called it something different, but this is what we call it at the moment. And it's been around, I think, for many, many years in some form or another. And originally it was the managers, so the assistant chief trial counsel and the chief, who met regularly to review the stipulations. And then through the years, it's evolved. Right now, the supervising attorneys are part of this meeting, and the attorney on my team in training and calibration reviews all of the stipulations that the office submits to the court, and then highlights for the group at the meeting different issues that he spots in those stipulations. And so this is an excellent opportunity to calibrate with all of the supervising attorneys in attendance. And so, you know, everything is pointed out, from formatting issues to terms and conditions that we've agreed to or not agreed to in a particular stipulation. If the level of discipline is slightly off, that is noted at the meeting, and we discuss. And the supervising attorney that has approved that particular stipulation has an opportunity to discuss the rationale for why they approved it and the thought process, and then the group discusses that. So this happens bi-weekly, and as needed, of course. I mean, we don't always have stipulations to review, but it happens. We have it scheduled bi-weekly and pretty much adhere to that schedule. So that is another excellent opportunity for us to calibrate the stipulations that are submitted by our office. And last on this first group is weekly attorney meetings. So all OCTC attorneys are encouraged to attend these meetings. They're held on a weekly basis, and they're primarily to discuss appellate decisions as well as hearing department decisions that have been issued in that past week. And we have an assigned attorney on my team that leads the discussion. They talk to the attorney, and whoever's case it was presents, does a short presentation of their case at the meeting for the rest of the office. We discuss the state bar court's decision, the rationale. We also discuss whether to appeal. We take an informal poll or vote at those meetings. The chief is usually in attendance at those meetings as well, so people can express their views. The supervising attorneys are in attendance at that meeting as well. And so this is a chance for the entire office basically to get together to discuss certain issues. So frequently the discussion centers around level of discipline, certain charging decisions, why we charged it a certain way. And so this is another excellent opportunity for the office to calibrate our thinking on particular issues. The chief is there to give her opinion as well on particular cases. So next slide, please. Other tools we use for calibration are trainings. We have, for the last year and a half or so, been using brown bag trainings on various topics throughout the year as training tools, but also calibration tools. And for example, we held a brown bag for the supervising attorneys only on charging cases of there's misrepresentations involved. That was last year. And we also held a training on analyzing SCLAR issues. We had another one on assessing level of discipline. And we also have one scheduled on breach of fiduciary duty cases. So these are presented usually by someone on my team, but not necessarily. Sometimes we get other managers or supervising attorneys in the office to do a presentation. And these are shorter trainings. They're usually hour and a half. We do these around lunch. That's why we call them the brown bag trainings. And they're also, as I said, used to calibrate, because as we discussed, level of discipline, for example, is one that we did where we give our view on assessing that and try to provide tips to the attorneys in the office to help them assess level of discipline, for example. That's just one example. Next up is we call them MCLE trainings. These are just basically longer trainings. Yes, go ahead.
Chris?
Yes.
Sorry about that. So Ellen's going to leave shortly. So what I'd like is to interrupt your presentation with about 10 minutes from Ellen and then go back to you.
Oh, that's fine.
Let's try that.
Okay, sure.
Thank you so much. I appreciate it. I have family coming in for the first time since COVID, and I need to go and take a break to get them. I want to say that, well, first of all, in case some of these committee members are not aware, it's been many years now that we've had discipline or attorney discipline standards. And what the standards are guidelines for the court to determine what level of discipline is appropriate based on what rule violation has occurred. And there's a great amount of contention between the defense bar and OCTC with respect to how the standards should be applied. From the defense perspective, the standards are guidelines. They're not mandates, and the case law supports that. Even the California Supreme Court in a case called Silverton, which is the case that is kind of the seminal case in this area, emphasized the fact that the guidelines are not to be applied in a talismanic fashion. So when we talk about calibration, we talk about consistency. I think the defense bar's position is that, to paraphrase Ralph Waldo Emerson, consistency, if foolishly applied, is completely inappropriate. And you can't have, I think, just as if we analogize to the criminal justice system, a cookie cutter approach in order to promote consistency over what's fair and just in each individual case. And I think more work needs to be done to gather statistics to determine what is the ultimate discipline that results, as opposed to what is the kind of opening salvo by OCTC when we begin settlement discussions. And I know we're going to have a separate presentation, I think, later today on settlement, but it really goes to the same issue. What is the appropriate discipline for each individual respondent based on the facts and circumstances of that case? And I have to tell you that there's tremendous frustration on the part of the defense bar, because from the defense bar's point of view, when we go in to try to settle a case, whether it's at a pre-court involved level, just informal settlement discussions, or in the pre-filing early mutual settlement conference at which a state bar court judge is present, or after filing, and then there's a voluntary settlement process. It's actually more of an MSC and not a VSC, but in any event, most cases do have a settlement conference post-filing of the notice of disciplinary charges. From the defense point of view, the prosecutors frequently are not listening to the judge's evaluation of the case. And from the defense point of view, the disposition in a high percentage of cases, maybe not the majority, but in a high percentage of cases, the disposition is not what OCTC sought and is actually lower. And I think that part of the problem is that in trying to perhaps please or make an effort to persuade whatever oversight body we're talking about, if it's an auditor or the legislature or whatever it is, the emphasis on consistency is misplaced. And it wastes a lot of time and resources. And I think if we were able to gather the statistics to compare what the state bar settlement position was, what they asked for at trial, and what the ultimate disposition was in the case, it would help the state bar when they do their calibration. Because a prosecutor can allege anything. The question is, what can you prove? And what can you prove by clear and convincing evidence to a reasonable certainty? So I would like to see more emphasis placed on the settlement process, it's already robust, but an even stronger and more proactive role for the state bar court judges in the settlement process. And frankly, more deference be given to a judge's evaluation of the case. A couple other things, and then I'll stop. There seemingly are a lot of new OCTC staff, and I appreciate this, that OCTC has put in place training and continuing education programs. But there's a lot of complaints now from the defense bar that the new employees don't seem to have a firm grasp of how the rules are interpreted. You don't look just to the black letter, you look at case law to see how the rules have been interpreted. There's a lot of rigidity. And in turn, this is going to increase the backlog. It's going to increase the burden on the courts. We're not going to be able to get cases resolved. And while I appreciate this newer protocol, as a matter of practice, the defense position, and I believe to an extent the state bar court judge's position as well, is that the supervisors are not actually involved when it comes time to resolve cases. There's an incredible amount of frustration over the fact that the lawyer who is present, whether it's at the early neutral evaluation conference or the voluntary settlement conference, has no authority, and it's impossible to get the person with authority into the room to try to work out a settlement. And I hear what you're saying about this new structure that's in place, but I can tell you it doesn't seem to be working. And so I think the system has to be changed. We have to have a system where there seems to be, it's a messenger problem perhaps. The individual who's reporting to their supervisor what the case is about may or may not be giving an accurate and comprehensive picture, because what the judge is saying to the parties and what's coming back through this staff attorney, individual deputy trial counsel, from their unseen supervisor don't mesh. And we need to fix that. It's causing a great deal of burden on the system and expense to respondents. I'm sorry, one last little point. I meant to mention in the last topic, this idea of measuring the backlog at the end of the year, that I'm happy to hear the state bar is putting in a rolling system, because not only is that burdensome on OCTC, it's incredibly burdensome on the defense bar, who every end of November and all of December, when people are trying to enjoy the holidays with their family, get a barrage of cases, including deadlines that can't be met. You know, you have to go to an E&EC within 2 weeks, or we're going to file the public notice of disciplinary charges. You can't physically fit in that many E&ECs in December. The court can't do it, and counsel can't do it. And I can't tell you how many times I've had a client have a notice of disciplinary charges literally filed on Christmas Eve. We need to fix that problem too. It's part of the same issue where we need to get earlier resolution. We somehow need to have more communication directly from the respondent, the court, defense counsel, with the supervisor who's making the decision, and that will help the whole system work much better. And I will join you again when I return from the airport. Thank you.
Okay, thank you, Ellen. We'll go back to Chris. And Chris, I know you have prepared remarks, so continue with that. And then at the end, to the extent that the schedule allows, I'll jump in for the balance of Ellen's allotted time. And then at approximately noon, we'll plan on taking a lunch break. So, and I'm assuming that anyone that has to take a bathroom break is doing so, and please do so as we go along. So go ahead, Chris.
Okay, thanks. So I left off on our MCLE type training is what we refer to, and these are more lengthy trainings that we do. Just a couple of examples that we go through. One we do from my team, the appellate team, and we emphasize, what's working, what's not, obviously from the cases that have been issued that particular year. We do it annually, and we go through the cases from that particular year, discuss the findings, and use that as a calibration tool. That's one of the things. We also do a training on the random audit of closed files, and more on that in a minute. I've got it on my list to hit that next. We have speakers from different organizations, one, like for example, LAP, to come in, so our attorneys have a better understanding of some of those issues that come up in settlement conferences. For example, we've had trainings on prosecutorial ethics to reinforce those concepts for our staff, specifically with respect to charging. And so those are some of the tools. We do several of those throughout the year. Another tool we use is new staff training by our training team. So we've made some changes during the past year or so to how we train our new staff. I understand the comments from Ellen, but I've gone through, and I don't know if, specifically which attorney she's speaking of, but the changes that we've made, if we've centralized the training. In the past, we have had different people from the office, so different supervising attorneys, some senior attorneys do the training of our new staff, and we've kind of rotated that throughout the office. We've changed that, and now we have our lead training attorney and calibration attorney do all of the training with one of our investigators, and they do all of the classes. We have standardized training outlines that we use, and they've been doing that for the past year plus or so. And so that is another way we've sought to calibrate and make our work process a little bit more consistent in our offices by the training. Let's see if I could have the next slide. Justin, oh, there it is. Thank you. Another is policy directives. So the chief issues policy directives, and we post those on our intranet for the staff. Now, they're not all related to calibration, obviously, but several of them are, and they're specific to different areas, such as our DUI. We have a DUI policy directive that relates to our transmittal process. Those are C cases, obviously, and so relates to transmittal of those cases, as well as the trial and level of discipline on those cases. So in that sense, we issue these policy directives, and it guides the staff, it guides the supervising attorneys in assessing level of discipline and charges on those particular cases. Now, we also use random audits. The random audit I believe Dag, I didn't hear all of his presentation, but I believe he was discussing the random audit, at least in part, and that's by the outside independent auditor. So that also assists OCTC in calibration. I won't go into detail because I think you've already heard about that, but they view a sampling of files from both offices and all teams in the various stages, so intake, investigation, and trials. The auditor provides the results to the management team here. I give a presentation to the managers, which is confidential because it involves personnel decisions, sometimes specific performance problems. So I can discuss that confidentially with the managers, which I do. And then I also provide a presentation to the office, obviously with not specific examples necessarily in terms of cases or case numbers, if it highlights a performance issue, but I go through the topics that the auditor has mentioned as potentially needing training, for example. She might comment that our staff has missed a few rule of limitations issues, as an example. And so the training team, my team would then put together some sort of a presentation in response to that, if that's a trend that we're seeing in the audits. So we do look at the audits. It helps us form our future trainings. And then I also go through some of the points that the auditor mentions in there if we've had issues with certain types of or areas of law or certain issues. So that is the tool that we use. We also use another type of a random audit, and this is the audit of open investigation files. That's performed by our supervising attorneys, and that allows them to randomly sample open investigation files. They usually pick, I think it's one investigation matter from each investigator that they supervise. They're selected at random. They obviously are looking for to ensure that the investigator is following our policies and procedures in investigating cases and to maintain consistency there. And they check for performance issues. They maintain a list with all of the communications performance issues that they've noticed in a binder. They prepare a memo for the chief or the OCTC manager that they submit twice a year. And so that's another tool that we use to ensure that the investigators are properly following procedures and protocols in the office. We also use, to a lesser degree, major case designations on significant matters. Obviously, these are not a huge portion of our caseload, but those decisions run up through the chief. And so there's consistency on dealing with those matters involving public officials and other significant cases. And then, as I mentioned when we started, the charging memos and draft NDCs that are approved by our supervising attorneys. And they're reviewed prior to filing. This is a tool for calibration. Obviously, it also represents the decentralized decision-making that I referenced earlier. So there is a lot of discretion involved by the attorney drafting them, but by using the tools that I've mentioned, the supervising attorneys the goal is that they are calibrated when they review these charging memos and approve them. So that's all. It concludes my part of the presentation. If there's any questions.
I have some questions, and then I'll segue into, I guess, the remainder of Ellen's time. First question is, who does the outside audit? Is that Elise?
Yes.
Okay, Elise
Well,
was
she's been doing them in the past. I don't know for exactly how long, but yes.
Well, say hello to her for me. She was my boss when I was a state bar prosecutor in the 90s. And she's terrific and very educated. And she's also somebody who leads Prosecutor Blue. So in that regard, is she by herself the best auditor for the role that she's in? In other words, she thinks like all the other state bar prosecutors. So are you really getting feedback from somebody that is open-minded about whether the appropriate resolutions are being done? And I'm not criticizing Elise because I like her a lot, but my point is that maybe a defense lawyer would look at what OCTC is doing from a different lens. Not maybe, definitely. And so if you're looking to benefit from the audit, aren't you better off with somebody that has a lens that's different than yours, rather than somebody who's just rubber stamping what you're doing because that's what she did? Just a comment. What do you think?
I mean, there's no question that a balanced approach is good. I'm not arguing that point. And I don't, the audits that I've seen are from Elise, so I haven't seen one that was not done by Elise, so I don't have that perspective on it. But I can say she does call out issues where she thinks we've taken too hard a line on a particular case or an issue. So in that sense, I think she is at least aware of those issues, and it's not a rubber stamp. I can assure you that she does call out issues where she thinks we've been too aggressive in certain cases, and that it wasn't warranted. So those issues are definitely addressed in the audit. Whether she has the same perspective as a defense attorney, you're probably right. She doesn't. I don't know. I don't know her personally, but she does. I can tell you that she does call out those issues, the ones that you're referring to, I think.
Well, I'm happy to hear that, and that's good, because again, what's the point of an outside auditor if the outside auditor is just coming in and rubber stamping everything? I think nobody gains any value from that. Does anybody else have any other comments to that?
It looks like Eloise has her hand up. I think you're on mute.
I don't have a comment directly related to Ed's comment, but I was following up on Ellen Pansky's concern about new staff. And, as Christopher was talking about the training of new staff, I wanted to say two things. Number one, I just acquired this book, Noise, by Kahneman. Maybe many of you have seen this. It was written up in the New York Times book review of books, but I am working my way through it. I think that this is a noise, a flaw in human judgment, and it applies to the way decisions are made, or not only bias, but all these other factors that affect us, whether we think we're impartial or not, or whether we're sharing a common calibration or not. I think that this is going to be a useful book for me to work through. and it has a section on if you want to reduce the noise in decision-making, whether it's in medicine or law or in education. I think that this is a book worth paying attention to. The other issue that concerns me came up last time when Melanie was talking about, recruiting new staff, going to the best schools, getting the best and the brightest to come in. But it sounds like there's a turnover of new staff that requires a kind of a constant work of Christopher and his staff to educate. And you can't always educate people at the same level in the same way when they come in with different starting points. And if they're coming in without ever having actually represented clients on their own, or dealt with difficult opposing counsel, or opened their own IOLTA account and gotten paid or gotten stiffed, these experiences that are common in the practice, whether you're, well, probably more common if you're in a solo or small law firm. I'm just wondering, when you come to the level of a supervising attorney, is there any metric that looks at what is the background of the supervising attorneys? If they are charged with or empowered to make these decisions, which no matter how they're carefully calibrated, do they have some kind of comparable experience with professional experience with the attorneys that they are making decisions about? So I'm concerned about the level of experience of the supervising attorneys, and that's just a statement of concern. I don't even know how to ask a question, but I'm just going to state the concern.
So if I could just make a couple comments based on what you said. One thing to keep in mind is that luckily our office was given some additional resources last year, which allowed us to add a whole new team. And so I think that that's one of the big reasons why there's some regular training going on. We added 19 new people to our office last year. So it does feel like there's a lot of training going on. I will say for the new staff that come into our office, the new attorneys in particular, it's rare that they don't have some kind of law practice experience. It's usually, we usually see people at least with 2 years, but upwards of 10 years coming in as new attorneys in our office. I will say, sort of interesting to your point, and I don't think we've done a study on this, but my best guess is that many of the people that come to us come from sort of other public service government type of agencies. Not frequently do they come with private practice experience, which is, I think, the point that you're getting at. And I do think, for our supervisors, I don't have the minimum qualifications in front of me, but I want to say that they have to have been in practice, not necessarily in our office, but in practice for, I want to say it's at least 5 or 7 years. It's something like that before they are eligible to promote into supervising attorney positions.
Okay, I'm gonna jump in Ellen's role now and respond to some of Chris's comments. And I'm gonna start with this. And I'd like a lot of you to chime in after I'm done on this one, because this is a problem we will not likely solve, because it's fundamental to our system of justice. And that is to say that we have an adversary system. And the adversary system is based upon generally the argument that Chris laid out, which is, on the one hand, every prosecutor's office in the world wants to create consistency. And every defense lawyer in the world wants to argue that his or her case should deviate from the standards, and that the standards should not be applied in a talismanic fashion. And I use that word talismanic in virtually every case that I have, because it is the best word ever for describing what every defense lawyer is trying to do. We are trying to say generally that let's just say the misappropriation of $5,000. Let's say that has, the standard calls for at least 6 months actual discipline for that. Our argument on the defense side would be, well, let's not apply that standard in talismanic fashion. Instead, let's look at the mitigating factors. My client is a 30-year practitioner who's never had discipline before. She was going through a divorce. She was drinking in a manner that she had never been drinking before. She lacked judgment. Her judgment was clouded. And for that reason, Your Honor, should consider giving her 60 days actual suspension. That is a pretty good example of what we do. And in that regard, the judges have to make the hard call on that. We're not necessarily ever going to see eye to eye with OCTC on that one. I take that back. I mean, cases settle. So you do see eye to eye, but that's the foundation for the disagreement. And so when Chris presents and says we have this calibration team, we're trying really hard to figure out what that $5,000 misappropriation should be for that 30-year lawyer who has never strayed before. Okay, I get it, but I'm still going to always make my mitigation argument. The mitigation is different in every case, and that's where we come back with you can't rigidly apply the standards. And so in that regard, this is a really nice intellectual discussion, but there's a certain reality to this, which is defense bar is never going to sign on to standards, period. No way, no how. And I don't know if there's a way for a prosecutor's office to not use standards. I mean, what would we have then? And so in that regard, there's a tension there. And I hate to do this to you when you're not prepared for this necessarily, Judge, but I'd like to hear your perspective on that too, because I mean, what are we trying to do in this committee? We're trying to create a system that's more effective. And is the argument that we should recommend that OCTC get away from calibration and consider every case on its own, and therefore there would be no standards? Maybe the group thinks that that's the effective way to do it. I'm not sure that I do. And again, I'm the guy on the defense side. I mean, I think we need standards, and we need to chisel. What I say to my clients is we need to chisel away at those standards. So, Judge, what comments do you have, if any, on that?
Well, one, Greg Fontescue's not here, but the standards exist I see both points, obviously, because I'm the independent arbiter, but standards serve a function, right, to remove the implicit bias issues, right? So we need standards. We just need enough discretion to deviate from them. So that's my observation, is that their standards are fairly inflexible given the case law. So I have to be intellectually honest. So I have to apply what exists. In your situation, the hypothetical misappropriation, I may think that she deserves no suspension, but will that bear out when you go through the approval stages? No. So I also have to be realistic. I can't be an activist and throw them out. I'm also confined to them. What's frustrating to me is the differences. I realize we're not a court of record. We're not doing criminal work, but there is more flexibility. And that is the trend in the criminal justice system to account for some of these historical issues. I can't dismiss a case when I think that it should not have been filed, right? I have to honor the separation of powers. But in a criminal court, you do have flexibility in a 1385 power. We can't do plea opens, I have situations where, and I have to respect OCTC, they plead in the alternative. You may have one, set of facts, but I have 10 counts. and we're in a settlement. I know this is kind of getting into the settlement conference discussion we're going to have this afternoon, but it's hard to then commit the parties to narrowing the notice of disciplinary charges, because I don't have any power to take it away. So, you know, in criminal courts, you can dismiss redundant counts. You have greater ability to kind of force the parties to meet more in the middle. And I don't think I fully have those tools that are available. Well, I don't have those tools that are available in a criminal court. So I'm not sure if I answered.
Well, you did, and you answered it with maybe even a bigger question, and I didn't know that you were going there, but that the question is, should this committee, this subcommittee, be looking at enhancing the court's powers to do things that you can't do? And it goes both ways, by the way, which is you just stated that you don't necessarily have the power to dismiss, but if you see a settlement coming in too low, then actually, I don't think that's a good example, because I just had that situation where a settlement I thought was a good settlement was rejected by the court. So the court does have power to do that. But could you just speak a little more on where you feel a little handcuffed? Because that may be something that this committee can run with, and in terms of a recommendation to, I guess it would be the legislature, but could you speak a little more about that?
What the direction that my wish list?
Yeah.
My wish list is if we could give discretion in applying 1.8, the SCLAR issue that Mr. Jaggard had raised.
Can you explain SCLAR for everybody? Because I think only 4 or 5 of us know what that means.
And I don't know what it is, because if you read the case law on SCLAR, right, when you look at the facts of SCLAR, okay, let me back up. So standard 1.8 is progressive discipline, and we did talk about that. So in other meetings, so 1.8A applies if you have one previous discipline. So under 1.8A, if you have one prior, it needs to jump up on a second discipline. 1.8B is if you have 2 priors, then the presumption is disbarment unless there's compelling mitigation. So I feel hamstrung, and I think I addressed this with Melanie at the very first meeting. I kind of touched on it. So if I'm literally applying SCLAR in a situation, or I'm forced to take a look at a situation where I feel that OCTC should have wrapped up all the investigation together, why do I have to impose higher discipline when this really should have been wrapped up? And this is not through fault of OCTC either. This kind of comes back to the investigation pressures and closeout rates and everything, and reporting misconduct. You know, we can't control when a complaining witness calls OCTC and fills out that form. So that is my frustration, why there should be a greater carve out on 1.8. And I've had respondents that have gone to trial only because the DTC could not get their supervisor to authorize something not involving progressive discipline. And I just don't think the priority should be there. There should be a situation where we get the bad actors and we apply 1.8B appropriately. And then there's these situations where, through no fault of anyone's own, frankly, the respondent is now facing progressive discipline on a second case where, you know, it doesn't necessarily apply. And so when I'm taking a look at that, I still have to look at the case law that creates these exceptions to 1.8. I can't just make it up. So if it's exactly concurrent in time, then there is case law that allows me to move away from it. But if it's not exactly contemporaneous, I have to look at the factors that are provided. So my wish list would be to have more discretion in applying 1.8 or not applying 1.8. And in terms of this plea open options, I think that would be, you know, up to the committee to explore whether or not that is appropriate or not. We are regulatory, so it is different from a criminal case. There is a reason why the court's power is more limited than an Article 6 judge. So that's a policy call that I really don't feel like I should weigh in on. But that is a frustration. And going back to, I think, Ellen and Ed, in terms of, and I know Mr. Jaggard's position about calibration and giving authority, I call 2, 3, sometimes 4 mandatory settlement conferences because of this going back and forth. And I think, I would say in the last 6 months to a year, I think DTCs do come in with a range. So that they'll have an idea of what their supervisor will approve on the low end, but anything outside of that, you know, I weigh in with my thought and what an assigned judge may feel they can do after trial, and to what extent it falls on deaf ears, I don't know. I don't track the statistics. Everyone's professional, and they at least pretend to say that they'll take it back to the assistant. I only have anecdotal observations on that, but that's another frustration, that they are given a range, but not necessarily the power to accept a counteroffer. And so we do more of that back and forth. So I don't know if I've kind of hit all the topics that.
I think so. And I think you've identified some topics that we need to talk about in the future, but thank you for that.
And Chairman, there are a couple hands up.
Yeah, let's go with the hands up, please.
I apologize because I'm taking notes at the same time. So if someone raised their hand before the other one, we'll get you both. Linda Schneider.
A moment on mute. I just wanted to, from my perspective, and that is just to refresh, I led the unit of the licensing section at the Attorney General's office for the last 5 years before my retirement. And we represented 30 different licensing agencies. So I just wanted to comment from a licensing perspective and the more general overview of what licensing does. And it, you know, and this is with respect to Ellen and Ed's comments about the, you know, fairness versus justice kind of a collision. And that is that licensing is important to discipline individuals who are causing harm and take them out of the licensed population if that's what's necessary, or address their conduct in whatever the appropriate way is. But also prosecutors in a licensing scheme and those that are prosecuting cases have to consider the integrity of the entire profession. So that's where you have the juxtaposition of the individual case versus the standards and the need to have consistency. So the integrity of the system requires that consistency so the public can rely upon the licensing system to know that certain things are going to be dealt with in a certain fashion. And it gives the entire public the confidence in the system that things are being dealt with consistently and fairly for their protection. So it will, from a defense attorney's perspective, you know, you're representing an individual client and you're going to do your very best for that client. But from a prosecutor's perspective, there's much more at stake. So I just wanted to offer that comment. Secondly, there's a huge amount of resources from my perspective going into this calibration, which I think is admirable for the consistency perspective. I haven't seen your disciplinary guidelines, but generally disciplinary guidelines for all of the Department of Consumer Affairs agencies, at least, well, maybe all, most at least, have different parameters for different offenses, like, 1 year to 5 years or probation, or whether it's a revocation or whatever the circumstances may be. And then also aggravating and mitigating circumstances that can be taken into account. And generally speaking, the aggravating and mitigating circumstances help you to determine where on the scale of discipline you fall. It doesn't necessarily take you out of the scale entirely, although disciplinary guidelines always indicate as well that every individual case has to be looked at individually as well. If there's certain circumstances that just, don't fall within any of the guidelines. So I just wanted to offer those comments and also ask whether attorneys who are being prosecuted, and because I'm aware the cost recovery is part of the disciplinary system here, if they're being charged for all of this calibration and supervision and all of those different hands that are in the pot as cases are evaluated. So those are my comments. Thank you very much.
Okay, it looks like Karen Bell has her hand.
I'm not sure if you can hear me. I unmute. Oh, thank you. Yeah, I guess I'm wanting to sort of back up because I feel like it might help our committee to have a agreed upon sort of definition of effectiveness, because and also where our sort of jurisdiction lies versus the fairness subcommittee, because this whole discussion, it seems, regarding consistency seems to me has a lot more to do with fairness, and where if you go back and look at, so what is effectiveness, it seems to me, again, you're looking back at what is the goal of the entire entity, which is to protect the public, right? So to me it's looking like there's two sort of paramount considerations. One is, are we repairing harm that is caused by attorney misconduct, negligence, etc. And that would seem to be much more focused on the person who's harmed than on the person who did the harm, right? So especially in a financial case, what does the person want? They want their money. The discipline of the attorney does not give them their money back, so they want their money. How effective are we at actually repairing the harm that occurs? I don't know the answer, but I think that's a worthwhile question, at least in terms of defining effectiveness. I think another is preventing future misconduct, right? And so, discipline is not a magic fix there. There's different ways that you can prevent future misconduct. And I think that's true even in the sense of protecting the integrity of the profession. Discipline, for one thing, takes an awful long time most of the time. So there's a huge delay there. So if you're relying on that to protect integrity, that's already going to be a problem, most likely, in most disciplinary systems. And furthermore, even discipline itself isn't necessarily it's not what people necessarily want. I'm not suggesting we throw, discipline out as a possibility. Obviously, in certain cases, that does need to occur. But I guess I'm sort of countering a little bit what Linda's saying, countering the assumption that it's all about, that it has to all be about discipline, and that it has to all be about, pulling people's licenses or pulling them out of circulation. I mean, sometimes that's the case, but not always. And if we're looking at it from the bigger standpoint of repairing harm and preventing future misconduct, we might be missing the mark if all we're looking at is consistency amongst cases that have already been filed. And so to go back, I guess, to what Ellen is some of her points, which I thought were pretty compelling, is like, what if we were able to increase the effectiveness of mediation in these cases and actually settle these cases earlier? That would go towards repairing the harm to folks if the discipline is something that they want, and it would go towards perhaps preventing future misconduct, and it would also help the staffing in the OCTC. So I feel like, for me anyway, like I just would feel like I was contributing, that this committee could contribute better if we sort of were all maybe, and not that we all have to agree, but at least have a discussion about what is effectiveness? What are we trying to accomplish with this committee? And, you know, what should we be looking at? So, and I apologize if any of those comments are out of order or not, you know, we've already sort of started on a path and then we're set on it, but I just feel like those issues are popping up for me.
So Karen, I think your comments were perfect because they couldn't dovetail better into the afternoon session. And by that, I mean, when you picked up on Ellen's comment about settling cases earlier and making the settlement process more effective, which I think is also an OCTC goal and a State Bar Court goal, that's what we will be talking about after lunch. So I think with that, unless, Justin, is anyone else raising their hand?
No, there are no hands raised.
Okay, so here's what we'll do. We'll take our lunch break now, and we have approximately 2 hours of presentations left. And I'm conscious of the fact that Ellen is probably at LAX right now. So after lunch, let's do a 53-minute lunch, come back at 1. And then we will hear from OCTC and Judge Wang regarding factors impacting case settlements. I will filibuster until Ellen gets back. Hopefully she'll be back around 2:30 or so, and then she can complete the defense side of it. But I am familiar with the defense issues and can speak to them. But I think we're trending towards probably completing today at around 3. And so that'll be our goal, with a couple of hours of discussion later, but it will be focused on the settlement, which I think, Karen, really goes more to effectiveness. And so yes, we did cover a lot of fairness. I haven't been to a fairness committee meeting yet, so I don't quite know what's going on there, but I think that on every level, there's going to be overlap between fairness and effectiveness in both of the committees. So I think that that I'm not going to stifle the conversation in our group regarding fairness, because I think it does cross over. But I appreciate your point. Okay, so with that, I will see everybody back at 1. Hope you had a good recording. Great. We're going to start the afternoon session of our effectiveness subcommittee. And with that, we have different presenters. There's my friend, Mr. Kumar. How are you? I believe you and your team are leading off the afternoon presentation, correct?
That's right. Thank you, Ed. Appreciate it. Good to see you. And good afternoon to everybody. My name is Anand Kumar. I'm a supervising attorney in the Office of Chief Trial Counsel. And I'm going to be presenting on the ENEC process, as well as the impediments that we see sometimes to case settlement. So if we can, by the way, I'll be talking about that portion of the presentation. I believe my colleague Rachel Grunberg will also be talking about moral turpitude, as well as the standards that we were discussing a little bit earlier this morning. And of course, Melanie will be jumping in from time to time with her wisdom as well. All right, if we could go to the next slide. Great. So this slide reflects the specific procedural aspects of the ENEC process. And particularly what we're looking at here is the fact that the State Bar, in order to initiate filing charges, we have to go through a certain process. And obviously, we've been talking a little bit about the ENEC process earlier this morning in terms of what that entails, how we can improve it, and so forth. But the first step to doing that is, once we've completed an investigation, our office, even prior to this letter, which we're looking at right now, which is called the Notice of Intent to File Disciplinary Charges, or what we call an ENEC letter, there is another letter that our office actually sends out now in response to certain concerns we heard. I'm also part of the bench bar committee, in which members of ADDC as well as the court participate. And we've looked at certain ways we can improve our process. And one of those things that I'm going to talk about in just a few minutes is getting as much information from respondents as possible, particularly with regard to mitigation. But in any case, what's required under the rules is that we send out this letter, the ENEC letter, in which a respondent then has 10 days within which to request the ENEC. If they do not request it within that time period, then under the rules, they have technically waived their right to an ENEC. Of course, if they do request an ENEC, then the State Bar will obviously participate in one, and then an ENEC is held with the court. We're going to talk about what that looks like in a couple minutes. In terms of timing, the court must schedule that ENEC within 15 days of the request. Again, that's by rule, and that's so that, again, the whole background from which we're looking at this process is that the State Bar disciplinary process is aimed at public protection. So from that backdrop, we have to timely and efficiently move forward with our cases. And so that's why we're seeing some of these timing elements that we're looking at here in this chart. Once the ENEC is held, either the case will settle or it doesn't settle. And then obviously if it settles, we have to submit a stipulation to the State Bar Court for its review and approval. And then depending on the level of discipline, specifically if it involves a suspension or greater discipline, then it actually also has to be approved by the California Supreme Court. So when we're talking about the discipline process, from our standpoint, especially being an arm of the Supreme Court, OCTC has to be looking at not only will this settlement potentially pass muster with the State Bar Court, but then ultimately will the Supreme Court sign off on it? And sometimes I think there's disagreement between the bar as well as ADDC, and even for that matter, the State Bar Court potentially about what's likely to pass muster with the Supreme Court. And we say this because if we err on the side of settling cases for less than they're appropriate to settle for, then it's possible we may get some of those cases sent back by remand order from the California Supreme Court. And we've seen that, including recently. So we always have to keep that in mind as the prosecutorial agency that is prosecuting these cases, to make sure that we're not only just looking at what perhaps an ENEC judge is telling us, but also what ultimately the California Supreme Court is going to say about our resolutions. So that's a little bit about the overview of the case settlement process. If we could go on to our next slide. So the name of the conference is called an Early Neutral Evaluation Conference. That's the perspective that OCTC is operating from when we participate in these ENECs. And that's specifically because that's what's articulated in the rule. If you look at the rules of procedure, specifically Rule of Procedure 5.30b, you will see that the language actually calls for the State Bar Court to have a judge who provides a judicial evaluation of OCTC's case to the parties. And so in that regard, that's the way that we are viewing ENECs. Now, the rule also goes on to say if a settlement is achieved by that discussion, then we should be submitting that stipulation to the State Bar Court for its approval. And that's usually what happens, obviously. So there are cases where we do actually even dismiss cases, or we do not file cases because there's nothing to dismiss at that stage. It's a pre-filing matter, so we just decline to prosecute the case because now we have more information. And so, just to clarify, I know there was a comment earlier that, with regard to the ENEC process, it would be helpful, to make these more effective mediations. But in fact, these are not mediations. Our view is that, again, settlement is a byproduct of the judicial evaluation, and that's the primary purpose of the ENEC. And so, one of the things that, just to also kind of clarify what actually happens at an ENEC, in case people here have not been to one, what happens typically is that the parties caucus separately with the State Bar Court judge and get the court's view on what's happening with their case. Really, where does the State Bar have any wiggle room in terms of settling? Has the State Bar perhaps looked at a couple issues or something like that? But one thing that might be helpful to that process in terms of making this a more effective process is, if there was some sort of tentative ruling by the court, at the outset of the ENEC. So that way both parties are being told exactly what the court's view is, and we can have something concrete on which to base our, wins and losses, so to speak. That might also help, make it easier for the State Bar to track, the data in terms of, did the cases settle for something more or less than what the evaluation that was given at the outset of the case. So that's one thing that, might be helpful to the parties and the process itself. But really, I'm going to be going through this a little bit more. The State Bar's intention in terms of the ENEC process, other than being, statutorily required to attend one, is that we have one meaningful ENEC. That is the most efficient way of proceeding in any case, is just to have one conference so that everybody can get out whatever's on their, on their chest, can put their cards on the table, and we can have an honest and candid discussion and meaningfully see if we can agree. That is the goal of this ENEC process. And so, at least as far as OCTC is concerned, if you could go on to the next slide. So let's talk a little bit about, the OCTC pre-ENEC procedures, because I think sometimes, obviously, not everybody in this committee works for OCTC, so it can be a little bit unclear as to how, the sausage gets made, right? If we pull back the veil, how does OCTC come up with its recommendations? Where does that come from? So that's what this slide is intended to discuss a little bit. And so obviously, in terms of the internal process, I'm going to discuss what we do behind the veil, and then we're going to talk a little bit about what the respondents may see, for example, or the court may see. And so, obviously what we're talking about, this whole conversation is premised on the fact that there's been a completed investigation by the Office of Chief Trial Counsel, which results in what's called an investigative report. Once that report is completed, the investigator makes recommendations to the attorney about which charges to pursue and what evidence supports those charges. OCTC attorneys are not bound by whatever's in that report. They have discretion over, obviously, which charges to prosecute if they get more information, or if other issues come up that may present difficulties in OCTC proving its case. We may have to reevaluate our charges, obviously. And so one of the things I wanted to talk a little bit about is how, this issue has come up quite a bit. OCTC line attorneys having settlement authority or full settlement authority, where that relies or is based on how is the settlement authority, where does that come from? How is that generated? What's the source of that? And what may not be clear to everybody here is that the source of the settlement range or authority comes directly from the line attorney. So the line attorney makes the recommendations to their supervisor about what the facts of the case prove in terms of the allegations. They make those recommendations incorporating an analysis of litigation issues. Those may include, for example, lack of witness credibility, either by our own, the complaining witness in our case, or it could refer to, there may be a translator that may be required. They may not be a sophisticated witness. We look at issues like the SCLAR analysis that was mentioned earlier. We take into consideration because obviously in terms of discipline, it's not, in order to have discipline, there's two components to it. I'm gonna come back to the ENEC process in a second, but just to make sure people understand, we have to have acts of misconduct, which constitute ethical violations, and then those violations have to warrant discipline. So you have to have both aspects of the situation in order for us to proceed. If there are cases where it's clear that there is misconduct, but it's not likely to warrant discipline, then obviously we have to kind of weed those cases out and use our discretion as a prosecutorial office. And obviously those are cases that the State Bar Court is never going to see for the most part, right? Those are the cases that we weed out prior to it going to an ENEC oftentimes. And so once that recommendation has been provided to the supervisor with their experience and knowledge is going to make an assessment of whether they agree with that attorney's recommendation. And most times, more often than not, we do. And that's because we follow a certain process. We look at the standards, and I'm going to obviously defer to Rachel to discuss that a little bit later on, but the standards take very significant, there's a lot of significance to the standards in our view, because the Supreme Court has told us that. And that's one of the reasons why we believe that some of those stipulations were remanded, is because the State Bar perhaps was not, focusing its disciplinary recommendations on the standards. So that's first and foremost what we look at. But within the standards, there's also discussion of aggravating and mitigating circumstances. I'll talk about that in a minute. But there are also ranges within those presumed sanctions. And again, I'll let Rachel talk about that later. Obviously, our recommendations also look at case law to see what what the court has said about some of these recommendations or violations in the past as well. And so based on that, that dialogue between the staff attorney and the supervisor, then that results in what you see as an ENEC brief, the statement that's lodged with the court. And so from an external process, or external view, what respondents usually see is that OCTC has completed its investigation. We send out, again, this post-investigative report letter. That letter outlines the fact that OCTC has made a determination that we are going to prosecute this case. And based on the fact that we're going to prosecute this case, we're inviting and encouraging respondents to submit any mitigating evidence that they may think is appropriate, so that we can take it into consideration for purposes of the ENEC or otherwise. Even if we don't go to an ENEC, we want to know what the respondent's mitigation is. It doesn't serve anybody's interests, including OCTC's, for the respondent to not provide that mitigation. We want that, partly because we're not trying to win at all costs. We're trying to do what's right, and that means taking into consideration both the aggravation and the mitigation. So we're trying to get that evidence as early as possible. And then the next thing that the respondents are seeing is that we send them this ENEC letter telling them that they have the right to request an ENEC, the right to request informal discovery, and which we would provide prior to the ENEC happening as well. So I wanted to kind of dispel this notion that OCTC attorneys do not have settlement authority at ENECs. They have full settlement authority. If we could just go on to the next slide, that would be helpful. So I'm going to come back to the settlement authority in just a moment, because it's tied into this next slide. So when we're looking at settlement stipulations, there's two components, primary components to any sort of State Bar settlement. And what we're talking about is culpability and discipline, right? And so in order to determine what violations a respondent is culpable for, we need to have a common or full understanding of the facts. And that includes obviously trying to get the mitigation, right? We want to know what the respondent's side of the story is. And that's something that, frequently is an impediment to settlement. There may be reasons why a respondent doesn't want to cooperate with the State Bar. There may be reasons why they don't want to provide information regarding potential culpability as early as possible. I mean, that it makes sense. So there are reasons why respondents might want to obfuscate or only share part of the information. And what that does is it has an effect on our ability to, number one, gain a proper full understanding of their side of the story to evaluate a case. And then number two, it's going to potentially delay any sort of settlement that might have occurred. So we may not have one at all, or we may have a delayed one. And so, that results in more filed matters that could have been resolved at an early stage. It also results in increased disciplinary costs for respondents. They oftentimes then, if they're not represented, they're going to end up hiring counsel to help, facilitate the submission of mitigation evidence. In fact, that's a very significant portion of what a lot of respondents counsel do for the state bar in terms of making it easier for us to settle cases, is they actually collect all of the mitigation evidence so that we can properly evaluate it. And so, considering that maybe even half of the people that we prosecute are not represented by counsel, all of this results in increased congestion for the state bar court and a wasting of judicial resources. So that's a big side effect of, the lack of evidentiary cooperation that we experience in OCTC at the UNEC stage. The second thing that obviously we were talking about a little bit is discipline. And so discipline, again, I'll leave this to Rachel to talk a little bit more about, but in short, it's based in part on aggravation and mitigating circumstances. And so those factors or circumstances are laid out in the standards. And so those are some of the factors that we look at and have to look at in evaluating a case. But again, we don't always get, some of the most powerful mitigation until very late in the process, particularly if you're looking at respondents who have health issues or family problems or, other issues like that. We don't get that mitigation early on because sometimes it can take time for them to gather that evidence. And perhaps, respondents weren't aware of how serious the case or the prosecution was at the outset. And so now they're scrambling to try to get that information for us. And so what that results in is, again, it causes multiple ENECs. And that's the notion of multiple ENECs. Number one, we think that it's not necessary because from OCTC's perspective, again, the point of the ENEC is to get an early neutral evaluation. And so it should only take one ENE to get that evaluation. We don't need to have multiple settlement or ENECs to get that evaluation. And then the second part of that is, from OCTC's perspective, once we have a sense of what the court is likely to approve in terms of a settlement and have some sense at the first time, we don't really necessarily, the parties don't necessarily need multiple ENECs with the court to actually accomplish that settlement. We're able to obviously discuss with one another directly what the terms of the settlement will be, and where necessary, obviously we can invoke the court's help. But from our view, we're able to do that on our own without necessarily invoking the court's help. And so, what we see from looking at all of that is that there are ways that we can improve the process, and we're trying from our standpoint to do that. But there are some things that obviously we cannot control from OCTC's perspective in terms of we can't, provide the mitigation for the respondent to ourselves, right? So from that perspective, there's only so much we can do as a prosecutorial office without overstepping our bounds in terms of these disciplinary matters. If we could just go to the next slide. So as I was saying before, our goal is to have one meaningful ENEC. We may have different interpretations of what that means. I understand earlier there was a comment made that OCTC does not listen to the State Bar Court opinions. I think there's a difference between not listening and not agreeing, and so we listen very carefully to what the court obviously has to say. In fact, there are many instances in which that's the supervisor's specific direction in terms of reviewing the actual discipline recommendation that was recommended at the outset, is to get that State Bar Court judge's evaluation. Perhaps we may not be able to prove a charge, and we have to look at the court's opinion to get a sense of what that's worth. There are many instances in which we are tasked with prosecuting kind of these nebulous charges. For example, sex with clients. These are issues which there's not a lot of case law on. And there's other acts of moral turpitude like that. And so it's a very much of an art, not just a science. And so we are interested in hearing from the court as to its opinion, but obviously we may not always agree with the court. And so, you know, in that sense, we just want to have one ENEC, have it be as meaningful as possible, and making sure that we are being as thorough in terms of hearing the respondent side of the story before we can properly assess what our case is actually worth. That's how we view this, and definitely for most cases, when you're talking about public discipline, the ENEC is just the starting point for settlement. Because, you know, once we file charges, which was going to happen anyways in terms of it being public discipline, we are just starting the process of settlement. So we may not agree pre-filing, but we could, you know, come to some better agreement on the submission, for example, of more character evidence or more mitigation, you know, 2-3 months down the road. Sometimes there are global settlements that impact our ability to settle cases. And so we have to have a further VSC, you know, in 3-4 months. Again, that's not a fault of OCTC or the respondent. It's just, that's the reality. And so we are not always going to be able to settle cases at the early stage, even if we wanted to. And so we're not going to just piecemeal out the settlements and drive up the disciplinary costs for the respondents. We have to try to have one meaningful ENEC. So that's something that we take meaningfully. And part of our mission, again, as you know, prosecutorial agency that's aimed at public protection, is public protection demands that we try to make this process as seamless as possible. That means that we should have only one ENEC. That means that we should try to file charges as efficiently as possible. It means that we should try to notify the public of public disciplinary charges. I mean, that's what we're trying to do. That's that's what we've been tasked to do by the Supreme Court.
Anna, we have a hand raised. Karen Bell, please raise your hands.
Sure.
So I just had a really quick question. I mean, first of all, thank you for the explanation, because there's a lot in there that was stuff I didn't know. So that's really helpful. But I was just curious because you mentioned the parties caucus with the judge. And I was wondering, given this hesitancy that it sounds like that oftentimes there is for them to actually share information, is there any kind of like, is there confidentiality assured to them when they speak to the judge regarding these mitigation factors and they just don't trust it, or there is no confidentiality assurance to them? I'm trying to figure out where's the issue there, because you're not getting, the reason why you're not getting these ECs to work well in a single shot is because there's a lack of trust, it sounds like, and people are afraid to disclose this information thinking it might harm them, right? I think is what I'm hearing. So I was just curious, if you could speak to that.
Well, you know, perhaps that might be something Mr. Lear or Ms. Pansky could talk to more, because obviously I've never represented a respondent in an ENEC. But, you know, from my perspective, there obviously is some confidentiality that if the respondent, or even if OCTC tells the judge, hey, we want to tell you this in confidence. For example, if we're telling the judge that our complaining witness is not very credible, you know, they may have credibility issues or something like that. That's not something we would want necessarily for the judge to disclose to the other side, right? So we do sometimes ask the court to kind of maintain some confidentiality with regard to some issues like that. But more than that, I don't want to speak to things that I wouldn't know the answer to. So I will kind of defer to Mr. Lear and Ms. Pansky about that.
And I can jump in, Karen, and that is to say that, at least in my experience, lack of confidentiality in an ENEC is not a concern for me or for my clients. And that can be easily framed by my communication to the judge saying, I'm going to share with you a fact from my client's perspective that we are not authorizing you to share with the other side. So same rules like you would have in any other settlement conference. That said, I don't know what happens with unrepresented respondents. And Anand just indicated that 50% or so are not represented by counsel. So don't know what happens there, and don't know, to your point, Karen, whether there's a chilling effect for an unrepresented counsel in an ENEC where that unrepresented counsel is holding back because of concerns of the confidentiality issue.
And it looks like Judge Wang has her hand up.
Okay. Oh, okay. I was going to cover this in my presentation, but following up on Ed and Anand, there is a difference between pro pers and represented litigants. So when Anand is saying preferably, yes, we should be able to cover a lot of ground in one ENEC, but the issue is with pro pers. Oftentimes, my first ENEC with them is pointing the standards to them, the aggravating and mitigating factors. I kind of take it on myself to coach them through the process because that's what's fair when you're pro per. So I'm going to have to respectfully disagree with Anand there on multiple ENECs. I think it's incumbent on me to allow the pro pers to have a second ENEC after they're given the information that I can direct them towards. So I do think there's a big difference when I'm doing an ENEC with a pro per and one who is represented. In terms of sharing and not sharing, I think the parties covered it. I'm kind of a double secret agent, so I do break out and I don't cross share, and I try to take really good notes so I don't. But in terms of what they're willing to share, yes and no. If they're sharing information in that conference and it's the same DTC who's going to prosecute him or her, they may be reticent in sharing that because they haven't quite figured out what their defense is going to be. And to be honest, in my private conversations with them, I say, look, you may not want to even say this to me because hypothetically, this may happen. An example would be, I have a lot of pro pers who, well, everybody, right? It's life. Everyone's going through financial or medical issues. It may involve a suicide attempt from a son. They were going through all of this. They don't want it in a public record of discipline that this was going on. And so there's a lot of things that go on. And I think that's why sometimes we do need multiple ENECs so that they can think through those issues. And I never press, a pro per in that moment to decide whether or not to share something. So I don't know if that answers your concerns here.
For a minute. So you can see how all of these things sort of conflict with one another, all these interests. And one of the things that I just wanted to point out, a couple of things, is some of the things that are on our mind as we're trying to move these cases along. It's just that, one, in particular, if you're talking about conduct that poses a significant risk to the public, is that through this whole process, there's no public notice that there are even there's an investigation or disciplinary charges pending. So we're concerned, and there are certain cases that we really want to make sure we get filed. And the other thing really just is that sort of what we talked about earlier, going back to Dag's presentation about the audit and the hyper focus on the aging of cases in the office. And all of this process that we're talking about, the ENEC process, is all part of that time, that 180-day time goal. So, we start getting really nervous then when the court wants to have multiple ENECs. And certainly I can agree with Judge Wang that in particular, it's challenging with pro per respondents who are not well educated about the process. And it sounds like some of that goes on at the ENEC. And I'm certain that Mr. Lear and Ms. Pansky would agree too that, oftentimes even when they have counsel, they've gotten it late into the process. So there's still work to be done at the ENEC process.
Yeah, I just wanted to follow up on this because I think something that may not always, as state bar prosecutors, we're in a challenging spot because given the high, and I don't know that it's exactly 50%, I just I'm guesstimating a little bit, but we are, unlike criminal prosecutors, we who are afforded counsel by right, if they don't have one, we frequently have to talk to respondents directly about the alleged misconduct, and we cannot give them legal advice. We have to be respectful, mindful. We try to give them the information, as Judge Wang was pointing to. We try to give that information to them. We're not trying to hide the ball or suggest that there's no mitigation that is available to them. It's just that they don't always want to hear it from us. And rightfully so. They should, have somebody impartial who's their hired counsel telling them these things. So we're kind of put in a difficult spot where we can't necessarily even give them all of the information that they may want. We try our best, but at what point are we supposed to tell them, look, here's the standards, and this is what the list includes in terms of mitigation, but the mitigation you provided may not be the best character letter. Now you're gonna have to go back to the drawing board and get a better character letter. Or you've shown that you had some health issues, but you haven't shown specifically that those health issues, causally contributed to the misconduct. So we're kind of put in a tough spot as in terms of OCTC prosecutors, and we're trying to balance everybody's interests. But obviously, as a prosecutorial agency, our interests are not going to be the same as the respondents or the court. So, it's very understandable why the court, in terms of their interest, may want to have more than one ENEC. But from OCTC standpoint, it's obviously it should be pretty obvious why we would only want one ENEC. I see somebody's hand is up. So.
Yeah, Alexia.
Yes, hi. I think you brought up a really good point and something that we spoke about at, I want to say, the first meeting of this commission. And I don't know that we ever got an answer of whether providing a group of attorneys for people who are not represented, that are low cost or at no cost to people facing these disciplinary issues, because I do think that has a lot to do with the effectiveness of OCTC and being able to process the cases faster. I mean, that's just kind of what I'm getting from listening to everybody. And so I don't know if someone from the state bar could comment on whether that was ever thought about, has been tried in the past.
I think I can speak to that because I was on the fairness subcommittee, and I think that is an area of focus that they are looking at. They're looking at all the costs that are imposed upon the respondents, and the lack of representation and the cost of representation is something that we discussed on Tuesday, and they want to discuss more in future meetings.
Okay.
Yeah, and if I could just add, that has been an ongoing discussion as part of the bar's look at reducing disparities in the discipline system too, and engaging with ADDC, frankly, on whether or not there might be some options there. And the other thing, and maybe Judge Wang can chime in on this or not, I believe that the court is working on some self-help material as well, which would certainly help.
I also wanted to just add too that there are certain types of cases where respondents are entitled to counsel. So for example, if they are experiencing mental health issues or infirmities or physical disabilities that may result in them being placed on inactive status. So I'm talking about a specific subset of cases, which is under Business and Professions Code 6007B and specifically B3. But what I'm referring to really is that those are cases where an attorney may go out on involuntary inactive status. For example, let's say they had a stroke or something like that. And so in those circumstances, the disciplinary proceedings may become abated as a result of whatever health issues they're experiencing. So in terms of getting their medical documentation and making sure that they are properly represented for purposes of going out on the involuntary inactive status, the court may appoint counsel for them. So I know that that's one area where that does happen, but in terms of disciplinary proceedings, that does not typically happen. But it's a really good point. So, one of the other things that also impacts our ability to have one meaningful ENEC, I've talked about pre-filing, the importance of pre-filing mitigation for us to get that. But another aspect of what happens at ENECs is, and this is interrelated, I told you I would come back to the whole line attorneys having full settlement authority. Sometimes what happens at ENECs is that respondents tell OCTC they are going to get them XYZ mitigation. And it's like mitigation discussed hypothetically. And we don't have an ability to view that mitigation. We don't know what the doctor is going to say or not say or whatnot. So sometimes what happens is we are being asked to discuss a proposed settlement that takes into consideration mitigation that we don't have that's otherwise supposed to be compelling. And so that makes it very difficult for us to know what's an appropriate settlement. And so what happens then occasionally, especially for our newer attorneys, is that they don't know how to process that information like on the spot, nor should we be expected to process that information on the spot. It's important information for us to consider. So that should take some time for us to review. Now, that may be viewed as, well, the line attorney doesn't have settlement authority. But the truth is that it's not necessarily reasonable or realistic for us, even as supervisors, to expect our attorneys to make a snap assessment at an ENEC about hypothetical mitigation that we don't have. That's not reasonable. Or even if they did provide it at the ENEC, to review medical documentation, we may need our own expert, for example. And so that can, delay the ENEC process. And then the last thing I just wanted to also discuss is OCTC has discretion regarding disciplinary costs. I see Ms. Schneider has her hand up, so we could take her question now.
I just wanted to comment from sort of an outsider's point of view that this early settlement conference before charges are filed is completely uncommon within the Department of Consumer Affairs licensing agencies. And the legislature has allowed licensing agencies, actually required them to file their accusations and publish them on their websites within the Department of Consumer Affairs for the purpose of informing the public about potential licensees, licensees' potential discipline coming up, and so that they're aware. And you've outlined a lot of reasons why this early settlement conference really should take place after the filing of charges as opposed to before. Number one being you have very short timelines, 10 days to give notice to the respondent and 15 days to set the conference. The respondent's not going to have time to be prepared for a conference, leading to all these continuances and the delay of filing charges and getting putting the public on notice. The prosecution of the case can't take place until the charges are filed, and that whole thing can be derailed by the defense just simply not getting the stuff over to the prosecution or dragging their feet, or I'm sure there's a million legitimate reasons, but still it causes that delay. And all during that time, the public's not put on notice. So, I mean, I know this is your system, but it's certainly more, it works better if the settlement conference takes place after the charges are filed, in my viewpoint and from my experience. So I just wanted to mention that. And I also had the question as to whether, if a case is settled before charges are filed, how is that done and how is the public put on notice? Thank you.
Great question. To respond to the question, it depends on the kind of settlement we're talking about. If the discipline involves what's called a public reproval or greater discipline, i.e. state suspension, actual suspension, or disbarment, then that's something that the public will be notified by. There's a stipulation that gets posted. It's attached to a case number. It used to be that it was attached to the member's profile page on the State Bar website, but now I believe that that's no longer the case. So you actually would go on the State Bar Court's website to see that and see what their disciplinary history and the specific facts that are outlined in the stipulation. And our stipulations are pretty comprehensive, in terms of facts, aggravation, mitigation, level of discipline analysis. I mean, there's a lot of, as Chris talked about earlier, there's a lot of calibration that goes on. So our stipulations, we try to pride ourselves on making them the best of any state bar in the country. And so that's to answer your question. All public forms of discipline would be posted, but if, for example, if it's a true private reproval, or well, warning letters not discipline, or agreements in lieu of discipline are not discipline, but the only type of discipline that the public would not be aware of is a true private reproval. So I don't know if that answered your question, Schneider. Okay, so but one of the things I did want to mention, and this kind of dovetails nicely with what she was just talking about, is, for example, if one of the common concerns that we hear from respondents in OCTC is that, well, you've got to settle my case before you file charges, because my discipline costs are going to go up, and that's not fair to me. That's going to impact my ability to resolve the case or whatnot. We understand that sometimes that there is a concern from respondents, and it may be legitimate. So, for example, if we have a settlement in principle, but we just literally cannot wait for the submission of the mitigation evidence because it's going to take time to get the medical records or declarations or so forth, we may say, look, public protection requires us to file charges now. But when you do get us the mitigation evidence, we have the discretion to assess costs at a lower level. And so that's one way in which we, as an office, are trying to make sure that we accommodate respondents' concerns about the settlement process to, again, make this more effective, make the process flow more smoothly. That's our goal. And obviously, that's not always the same goal for respondents, but that's our goal, is to try to move this along as quickly as possible, but as fairly as possible as well. I think those are all the points that I had. So if anybody has questions, now would be a good time to discuss.
So before we go further, and who's next? Rachel?
Yeah.
Yeah, I'm going to do the ADDC comments so that we keep it substantively on topic. I have a few comments on the ENEC process, and I'm jumping in for Ellen on this one. So a couple really important points to the group in general, and that is that the ADDC, the defense lawyers, really value the ENEC process. And in particular, where we have a very high level of frustration is in not having the ability to do ENECs for criminal conviction matters. And let me just give you a little background on that. So there are different types of matters that are prosecuted by the state bar. One group of matters would include what are called original proceedings, also known as O proceedings. And that's probably the bulk of the proceedings that are prosecuted. And that would be things like failure to perform your duties as an attorney, failure to communicate, client trust account violations, garden variety type of things where lawyers breach the rules of professional conduct and or the business and professions code having to do with the State Bar Act. So with criminal convictions, and anyone jump in and correct me if I'm wrong, I should get this right. But generally when a California lawyer is convicted of a crime and there's finality to the conviction, then the State Bar is put on notice of that attorney's criminal conviction. And that then initiates a process where the State Bar, I guess it goes to the court, it gets transmitted to the court for a determination as to whether that criminal conduct warrants any discipline. And once that transmittal goes to the court, then essentially the matter is a public matter. And that this is really important at this point. The frustration from defense counsel is that once that transmittal has happened and it's a matter of public record, then there is not an opportunity to achieve a private reproval that remains private between the State Bar and the respondent. And then secondly, and this is really more to the point, that there's not an opportunity for the early neutral evaluation conference prior to the transmittal. And in fact, I'm dealing with the situation right this second that I have a client with 2 DUIs, best community service, best mitigation evidence that I've seen. Last DUI was 8 years ago. And everybody agrees that it's a low-level discipline case, and that this would have been an ideal case to have had an early neutral evaluation conference prior to the transmittal. And we are a private approval would arguably be an appropriate discipline in this context. Because we didn't have an opportunity to do an early neutral evaluation conference, if the private approval is what the ultimate discipline is, then it's a private approval with public disclosure for the rest of her career. And in that regard, the unnamed judge at a settlement conference agreed with me that this sure is a shame. And I'm sure, well, I'm not sure, but I'm not sure that OCTC wouldn't agree with me that an ENEC in this context would have been a nice opportunity. And so my point on this is that this to me is not really controversial. Everyone with whom I speak in the virtual hallways seems to agree with me generally that an ENEC in the context of a criminal conviction referral makes sense. So it might be the easiest thing that this committee can do and really affect change, not huge change, but change in the system and make sense. And I'd be curious to hear if Melanie or Steve has any strong opposition to that, because to me, it seems pretty straightforward. And I don't know the answer to my next question, and maybe Melanie or Steve or Anand can respond to this, which is, okay, if we all agree, hypothetically, how do we change it? What do we do? What's the mechanism? What can this committee do to get at least an incremental change like that? Melanie?
Well, I think that the rules of procedure would have to change. I mean, the reason why it happens this way is because these cases originate in state bar court, unlike the other cases that you've talked about. I think it's something to explore. I think there are a lot of procedural hurdles for us to get through in order to get there, that we would have to see whether or not they were feasible at all. Just the volume that we deal with, quite frankly, right now, makes it challenging. But that's how it would change, is through rule of procedure.
And I figured as much, but I'm really disheartened by your comment that there are an awful lot of hurdles to go through to get there, because it seems like a no-brainer where there's not really a good policy decision not to do that. We all agree, why can't we just flip the light switch? And I get it, I've been around, and things don't happen fast, but that to me would be something this committee could do, should be able to do really quickly. And I haven't heard any opposition to that from anybody in the hallways, and I'm happy to listen to opposition to that here. But I think that that's part of what effectiveness is all about. Let's make the ENEC process more effective. What's one way to do that? One way to do that is to have it apply to criminal convictions as well. So that, by the way, to everybody, that you can tell that this is a bit of a rant by me, because I've been ranting about this for a few years, and the ADDC generally is to a person supportive of some kind of change. Haven't spoken to a judge who's pushed back on that either, not on the record, off the record. And I don't think I've spoken to a prosecutor off the record who has a strong feeling that there should not be ENECs for criminal convictions. So I think that's one somewhat easy change that hopefully this committee could help effect.
Chair, there's a couple hands up. Steve.
Sure, great.
Thanks. I am not necessarily expressing an opinion about whether it is a good idea or a bad idea to have the ENEC on C cases, although one of the things that I have learned in my 4+ years at the state bar is that many things that start out with good intentions have unintended consequences. And one that I would be worried about is that we would suddenly find that those criminal conviction cases would be considered as part of our backlog now. I think we would just have to be very careful about the way that we go about it. Currently, criminal conviction matters are not considered part of the statutory backlog definition for the reason that Melanie said earlier. They originate in state bar court, and depending on what happens with that, it would be very interesting and difficult to have that be included in the statutory backlog for the primary reason being that those cases are almost exclusively beyond our control. We are waiting for finality of those criminal convictions so that we can then transmit them. And there's nothing that we can do absent that.
So I just wanted to also add to that and just point out that if you look at Business and Professions Code 6101C, that's where what Steve is talking about. That is the statute that requires OCTC to transmit the records of conviction within 30 days. It doesn't say you can, it says you shall. And so we are statutorily obligated to do that. And in fact, that time period was much shorter, I believe, than 30 days before. I think it was like 5 days or something very short.
It was 5.
Yeah, and so long story short, we actually said that wasn't a sufficient amount of time for us to have some sort of meaningful understanding about whether these should be transmitted at all. And so long story short, we worked to get it up to 30 days, but Ed, in response to your concern, that looks like something where the statute would need to be amended or repealed in order for there to be some more change on that.
I want to be very clear about this. I'm not criticizing OCTC on this issue. On other issues, sure, but not on this one. This one I understand is a statutory issue. What I'm suggesting generally to the committee and to anyone that'll listen is that we work in lockstep to try to to revise the statute and the rule of procedure in order to affect what I think is incremental change, but important change. So it's not a criticism. We all have to work under the rules. I get it. I have a problem with the rule.
Well, I also just wanted to add one further thing, just so we're keeping this in context. The C cases that Ed is referring to, these are matters involving public convictions. These are already publicly available information that the attorney has been convicted. So these aren't necessarily the same as other state bar matters, which the public does not have available to them or may not know about beforehand. These are cases where there's already a public conviction.
Correct, except the case that I just mentioned, both of the DUIs have been expunged. So that it's just all the more frustrating that this woman who wants to run for public office where the criminal convictions have been expunged from the record will potentially appear on her state bar membership record in a manner that I think could easily have been resolved with a private, which is off the table. So it lined up as the perfect case to talk about today about too bad that we don't have an early ENEC, because we could have settled this easily for a private. That was my point. Okay, any other hands up, Justin?
Judge Wang.
Okay, good.
Just following up, I know Ed's been talking about it from the perspective of his clients, but from the perspective of the courts, that's less litigation in the state bar court if we could resolve these C cases at an early neutral evaluation. And I am talking, and I would say in large part it would be those DUIs, because I can't recall the last DUI that well, actually, that was, there is a published January case, but of a DUI going to trial. They really rarely go to trial. And so if we can catch those at the early end, I think it would be more effective as a system overall. But I do acknowledge the statutory issues that are going on. And I think this issue has been raised at BBC meetings, and we probably should continue talking about it there. So to the extent that it, you know, we may or may not be able to make any headway here in terms of a recommendation, I think it's still worth continuing in that context.
Okay, so back to me. The other pushback that I have on Anand's presentation is his general theme that one ENEC is enough. And I don't agree with that. The defense bar does not agree with that. There may be situations where one ENEC is enough, and that in particular, for many of you that don't appreciate this, is if the state bar comes in and says disbarment on a case with a sizable client trust account violation, there's not I can't think of too many situations where a follow-up ENEC is going to resolve that case. So there are certainly exceptions where one ENEC works. I've had many matters where we've had multiple ENECs where the matter was ultimately resolved at an ENEC. So I wouldn't want any kind of steadfast rule that limits this ENEC. Then also the other thing that I hope everyone appreciates is that once a notice of disciplinary charges is filed or a matter is live in state bar court, then the trial date is approximately 4 months thereafter. So things move really fast in state bar court, where there is a situation with a larger case. Multiple ENECs can help to pull the case together for the purposes of OCTC having a better understanding as to the underlying facts and circumstances that then would promote a settlement. I think once the NDC is filed, it moves so fast that it's hard to necessarily pull everything together from a defense point of view to be able to educate the Office of Chief Trial Counsel as to all the substantive and factual issues. So again, I'm a big proponent of the ENEC and multiple ENECs. I was further curious about Anand's comment that OCTC line attorneys have full settlement authority. And my question on that is that different than at a voluntary settlement conference, where at least my experience has been they don't have full settlement authority? And I'll pose that question to Anand.
Yeah, so it's exactly the same. In other words, the line attorneys, they are only enabled to discuss settlement once their own recommendations have been evaluated. And so that conversation in a C case, that will happen before a VSC, but in every other type of case where the state bar initiates charges, that conversation or dialogue happens prior to us filing charges. So in other words, the settlement authority or range is confirmed prior to filing charges in almost every case.
Well, but how do you respond to this? And I don't mean to be picking on you, but a situation where the line attorney comes down with authority, a range of authority, and then through the settlement, the robust settlement dialogue, the line attorney understands and appreciates that maybe he or she didn't either comprehend or didn't have all the pertinent facts to be able to make a decision that was informed. And so, and further needs to go back and talk to supervisor. I hear this all the time. I think not all the time. I hear this, so does Ellen. And so we're not able to resolve the case at that time because line attorney has to go back to supervisor in order to get further authority. And so that's where I push back and I say, I don't agree that OCT line attorneys have full settlement authority I just don't agree.
Well, I see Judge Wang was raising her hand, but I did want to respond to you, Ed. So I'm happy to let Judge Wang go first if you'd like, Judge.
Oh, I think I was just going to follow up saying I think we're just using the term differently. Yes, the OCTC, the DTCs have a range, but if the counter offer is outside the range, the answer is no. So do they have full settlement authority? The answer is no, not really. They have a range that they're permitted to go to. If there is a counter offer outside that range, and Mr. Lear had just brought that up, if there's additional information, they have to go back. That's why I have multiple settlement conferences and I agree with you. The DTCs are good about saying this is the range, this is where I can go. Outside of that, I need to go back. And they are always open to hearing the court out saying, if X, Y, and Z pans out, would your supervisor view it differently? And that's why I have multiple conferences. So I think we're kind of using the term differently, but I think that's what the situation is.
Well, and I appreciate everything you just said, Judge. And same with Ed. And I think that's one of the first things that I had pointed out in terms of our goal is to have one meaningful ENEC. And so what that means is we want the robust discussion of all of the relevant or pertinent facts. We want the respondent's version of events, but we want it way before the ENEC. So, in other words, the reason why there's a range is because that's the informed evaluation by our office. That's not just a range because we want to have a range. That's the range because that's what we think the case is worth. And so if it turns out that we're now changing the facts, then that means that we may have to change what the case is worth. So that's where, in terms of us trying to, we're doing everything within our power, including sending out the post investigative report letter to let the respondent know that we want their side of the story. This goes all the way back to the investigation. We're asking for them for their side of the story. We cannot even file charges against a respondent unless we ask them for their side of the story. So we, at all stages, we're trying to get the respondent side of the story. It's just when that happens at a late date, including during the ENEC itself, it's not reasonable to, in my view, or I think in our office's view, to expect for us to make a snap assessment when that whole process of making an informed decision about what the range should be can take weeks. We literally go through the standards, we go through relevant case law. We can't just be expected, I think, to make a snap decision because there's a delay in providing all of the facts. I think that's where we may just disagree about what the E&E process is really there for.
Okay, good. So let's move on. And is Rachel up next?
Yes.
Yes. Good afternoon. My name is Rachel Grunberg. I have been with the bar approximately 22 years, and I'm currently a senior attorney in the Office of Trial Counsel in the San Francisco office, and I'm one of the appellate attorneys under Chris Jaggard, who you heard from earlier today. And so it's my pleasure to be here today. Thank you for having me. I want to start off just by globally saying that I say this, ad nauseum, but what we do is it's not rocket science, but it's very nuanced. And unlike other licensing agencies, I know we heard from Linda Schneider, she represents other licensing agencies, et cetera. We are considered something that's called sui generis, one of a kind. So what we do is basically we make recommendations to the Supreme Court. Everything we do is in an advisory capacity, basically, to the Supreme Court. And particularly our office, trial counsel, we are mindful of the fact that everything, every disciplinary outcome when it results in suspension or disbarment has to be approved by the Supreme Court. So, these discussions that, discretion, do we want to deviate? Do we want all of these things? We're mindful of the fact that we may want to do a whole host of things, but ultimately, everything we do has to be approved by the Supreme Court. And so we work within that sort of parameter and the case law and the standards. So that's our starting point. I know for those of you who are unfamiliar with the State Bar, I don't know who on the task force here is unfamiliar with the State Bar, but so we start with the standards. We start with this concept of the fact that everything we do is a recommendation. And so that, adds to some of the reason that there's, all these levels of review. There's this tension between discretion and consistency and calibration. We ultimately need the approval of the Supreme Court. So I start with that premise. But I want to start with the standards for attorney sanctions for professional misconduct. There are basically three purposes to the standards. They are to determine the appropriate sanction in a particular case. They are also to promote consistency across cases dealing with similar misconduct and surrounding circumstances. And finally, they help fulfill the primary purposes of discipline, which again are threefold: public protection, maintaining the highest professional standards, and preserving public confidence in the profession. Now, rehabilitation can be an objective in a particular case, but the primary purposes of discipline are paramount, and rehabilitation cannot be inconsistent with those goals. So in a particular case, we could send someone to the alternative discipline program, or alcohol counseling, anger management, psychological treatment, that kind of thing. But again, rehabilitation is not the primary purpose of our disciplinary process. It really is the other three factors that I just discussed. So the history of the standards, I think it's really helpful to know the history of where we've been and what we've done before and why we've done it in order to evaluate where we want to go from here. So in 1985, the State Bar, through a collaborative effort between the State Bar Court and the Office of the Chief Trial Counsel, developed proposed disciplinary standards. At the time, the ABA, the American Bar Association, was undertaking a similar project and had prepared draft model disciplinary sanctions, but they had not yet been approved by the ABA House of Delegates. And so California always has to be different, right? So we considered the ABA standards in the proposed ABA standards at that time in our vetting process, but we opted to proceed with our own proposed standards, which were ultimately adopted by the Board of Trustees, then the Board of Governors, in November of 1985, and they became effective in 1986. And the standards remained in effect for nearly 30 years without any major modification whatsoever. And then in 2013, after a modest cleanup of the standards, which included primarily technical and stylistic revisions, the board appointed a disciplinary standards task force to evaluate whether major substantive modifications, if any, were needed to the standards. And the task force, I want to emphasize, was made up of approximately 23 members representing a wide array of attorneys and members of the public with expertise and interest in this area. I was part of the task force, so I just want to let you know that. And the task force included members of the Board of Trustees, OCTC, the State Bar Court, the Office of General Counsel, the Supreme Court, Beth J., who was then the primary principal attorney to the Supreme Court, was present, CJP, members of Respondents Bar, academics and ethicists, members of other regulatory and licensing board. We had public members, we had former State Bar Court judges. I think Ellen Peck was a member, and we had members of other prosecutorial agencies, I think the AG's office, DA's offices, and we had public defenders. So it was really a wide array, and they took a really deep dive into whether wholesale changes should be made to the standards. And so this evaluation took place between 2014 and 2015. And some of the ideas they explored included whether to remodel the standards to align more closely with the ABA standards. The task force took a really close look at the ABA standards, but ultimately decided it wasn't a good fit. The ABA model includes terms such as negligence and admonitions that were really inconsistent with the way the California State Bar approach levels of discipline, right? Admonitions are not considered discipline in our system, and we don't discipline for negligence, but the ABA, does. Yet another idea was to create detailed disciplinary ranges similar to sentencing guidelines. So those of you in the criminal arena will understand sort of the tension between sentencing guidelines where there's no discretion, and then sort of ranges where there are. Again, after studying this model and hearing from the members of the task force ultimately decided not to go with sentencing guidelines in favor of keeping the existing model that includes ranges of discipline, which allows for discretion. The task force did recommend, however, several substantive changes to certain standards and a wholesale cleanup, so that they read better for comprehension, for consistency, they renumbered them, things like that. But we had a lot of standards that were, I'm going to call them catch-all standards, where it was like, here's the range for the violation of oath and duties. And the task force decided we should break out some of the catch-all provisions into more specific standards that addressed certain violations. So for example, conflicts. So standard 2.5 now addresses representation of adverse interests. 2.6 addresses breach of confidentiality. 2.8 addresses fee splitting with non-lawyers. 2.9 addresses frivolous litigation. 2.13 addresses sex with clients. These are all stand-alone standards that address specific acts of misconduct. They were intended to again, give more detailed guidance as to what the range of discipline should be. I think another really important thing is that we changed the precatory language of almost every one of the standards to say that the sanction range was now the presumed sanction. And this was intended to create greater weight in terms of what the starting point was for the disciplinary analysis. So from OCTC's perspective, when we come to the table with a disciplinary disposition, what our take is, we are primarily looking at the standards which talk about the presumed sanction. Of course, there's a range, of course, there's a discussion, but that's the presumed starting point. So that's important to understand. We also broke out, the standards task force also broke out certain things like the misappropriation standard, which is now standard 2.1, kind of combined intentional and grossly negligent misappropriation. They are now broken out into separate standalone standards. And we also added enhanced guidance on how to weigh and balance aggravation and mitigation. Standard 1.7 tells you how to weigh and balance. And we created a more robust and detailed list of factors in aggravation and mitigation to consider. Those are standards 1.5 and 1.6. So these are just a few examples of what we did not really that long ago. These new standards became effective in 2015, so just 6 years ago. So I want to talk a little bit about the application. OCTC's disciplinary analysis, like I just said, always begins with the standards, and then we look to relevant case law for guidance. Again, the purpose of the disciplinary proceeding is not to be punitive, but to inquire into the fitness of the specific attorney's ability to continue in that capacity for the protection of the public, the courts, and the legal profession. And as a regulatory agency, we do strive for consistency. We are mindful of the fact that the Supreme Court has said there is no fixed formula in determining discipline, but we do use the standards as our guidepost to decide, what level of discipline we're going to recommend. And that includes all of the relevant factors, such as aggravation and mitigation. And so aggravation and mitigation. So again, the standard, when we're talking about specific act of misconduct, is where we start to determine what should be, again, the presumed sanction. And then we look to aggravation and mitigation. And under the standards, there is a list now, a pretty robust list of what those aggravating and mitigating factors are. It's not an exhaustive list, but it is a pretty robust list. So aggravation can include things like prior record of discipline, multiple acts or a pattern of misconduct, intentional misconduct, bad faith, dishonesty, overreaching, uncharged misconduct, significant harm to the client, the courts or the profession, I'm sorry, the administration of justice, an indifference on the part of the respondent, lack of candor or cooperation, failure to make restitution, and the high level of vulnerability of the victim. I think Melanie may have talked about this earlier, but when we have a elderly or infirm or immigration client, maybe who English isn't their first language, those are the kind of things that factor into vulnerability. And mitigation, on the other hand, there's also a very robust list there. It can include absence of prior discipline over many years with present conduct that is not likely to recur, good faith, lack of client harm, extreme emotional, physical, or mental disabilities directly responsible for the misconduct, which are now abated, and it does require expert testimony, candor and cooperation, extraordinary good character, prompt and spontaneous remorse and recognition of wrongdoing, remoteness in time or excessive delay on the part of bringing the charges, and restitution made without threat of discipline or legal proceedings. Again, not an exhaustive list, but a pretty extensive list. I also want to mention that the balancing of the factors is not a one-to-one ratio. So just because you have 3 factors in mitigation and 1 factor in aggravation doesn't mean mitigation outweighs aggravation. The balancing of factors, has to take into consideration what the actual misconduct is, etc. And so, for instance, sometimes the harm can be so significant that it's going to overcome all the factors in mitigation. And that's why the standards actually say that we should consider the factors alone and then in balance with all of the other factors. So I think the standards actually provide really efficient, effective guidance, fair guidance on how to use them. If we read them, I think that there's actually really good language in there that tells us what, how to analyze a case, how to balance those factors, and how to come to the right resolution. And then I want to talk a little bit about deviation, because there's been a lot of discussion about that here. And the reality is, it's true that the standards are not approved by the Supreme Court, oddly, right? They are, again, they were developed by this task force. We had members of the Supreme Court on the task force, but they are approved by our board. So they're not binding on the Supreme Court, but the Supreme Court has instructed that they ought to be followed whenever possible in determining the level of discipline. And again, we've heard today that the talismanic observation of the standards is not required, but I will tell you the Supreme Court has said that we should follow them. And in 2005, the State Bar Court was taken to task for not following the standards in the seminal case of Silverton. And we have had several stipulations and cases returned to us for not following the standards. And what the court has said is that as long as a recommendation falls within the disciplinary standards, they will accept it unless they have grave doubts about the propriety of the recommendation. That doesn't mean that we can't deviate. That's not, the case law, but you have to have really good justification. It's not just that there's a sympathetic respondent, because they are looking at all 3 primary purposes of discipline, and one of which I think Linda articulated it very well was that we have to also look at the integrity of the profession and other things. And so they're looking at everything. It's not just the individual respondent, although that is important. Again, I think the standards, if we read the standards, they provide really good guidance. So there is a standard 1.7 B and C that talk about, when it's appropriate to deviate. And it specifically says in determining whether to impose a sanction greater or lesser than that specified in a given standard, in addition to the factors set forth in the specific standard, consideration is to be given to the primary purposes of discipline, the balancing of all aggravating and mitigating circumstances, the type of misconduct at issue, and whether the client, the public, the legal system, and the profession was harmed, and whether the member is demonstrating a willingness and ability to conform to ethical responsibilities in the future. So it tells us what we should be looking at in assessing whether or not deviation is appropriate. And then the Supreme Court, as well as the standards themselves, standard 1.1 tells us that any deviation requires a clear, articulate, and compelling reason. So I understand that sometimes, we enter into a case, there's sympathetic, factors, but the standards are the starting point, and that's where OCTC comes from when we, come forth with our recommendations. Sometimes, there's a standard there on commingling. I know, it creates sort of controversy. It says the starting point is 90 days. That is the presumptive standard. That's where we come from. There's recent case law and has been litigation on it, but I think that there tends to be this attitude that OCTC is out of whack. We are following the standards. So I just want to be clear that that is what OCTC starts with. That's where we, begin our analysis. And if we get new case law on it, or there's Supreme Court mandates or legislative mandates, we will follow those. But that's our starting point. So that's my discussion on the standards. I can move to my next topic, which is moral turpitude, but I just want to see if anybody has any questions first on this.
Ellen, did you want to chime in on this?
Yes, thank you. We have been observing that it seems to be a new protocol for OCTC to rely almost to the exclusion of everything else on the standards. And so, for example, in my office, when we do a response to an investigation, or let me digress for a moment, I'll come back to that. When we do a response to investigation, or when we do an E&EC brief, or when we do a VSC brief, or when we do a trial brief, we're always going to include case law. And we have a pretty deep and comprehensive body of case law, including the California Supreme Court cases, of which there have been very few in recent years, because once they adopted the rules delegating most of the disciplinary process to the state bar, we now have the review department of the state bar court. And the review department of state bar court issues formal published opinions, which are precedent in state bar proceedings. And recently it has appeared that the Office of the Chief Trial Counsel is ignoring, sorry to put it bluntly, but ignoring all the case law. And I just noticed, Rachel, that when you mentioned what it is that that OCTC is relying on, you mentioned the standards and legislative guidance, but not case law. And all of the cases, virtually all of the reported disciplinary cases evaluate case law, just like in every area, every other area of law. You're going to look at the facts and circumstances of that case, and you're going to determine, based on precedential law, what should the disposition be. I think it's a mistake to rely so heavily on the standards standing alone, because it's not helpful to the court. And at the end of the day, the case isn't going to be decided just based on some superficial summary statement of a range of discipline. And I think that that's part of the reason why we're having to try so many cases, which takes us back to the backlog issue as well. I think that the solution to the state bar's backlog and to resource issues always comes back to, let's find a way to settle more cases. And the way to do that is we have to look at applicable case law. So I think the defense bar objects to that approach, and we would urge some reconsideration of it because it doesn't move the ball forward.
Okay, so I just have a couple comments. So the new standards took effect in 2015. Again, like I said, they use the word presumed, and some of the standards changed. So for instance, violation of a court order used to say suspension to disbarment, and now says actual suspension to disbarment. So there is a wide range of case law out there, I grant you that, but it's the pre-standards change. Again, the misappropriation standard has now changed. It's broken out into intentional gross negligence. There's not a lot of case law that really evaluates the standards 2015 and on. So I agree with you that there is case law. I agree with you that we should be using case law, and we do use case law. But I also think that there's a lot of reliance on old case law that is out of date, that is not consistent with the new standards, again, that uses the language presumed. So that's our starting point. And that's why when we come to these, E&Es, these VSCs, these are the discussions we're having. It's not that we're not listening, we just disagree. And that's why these cases, go to trial. It's not that we're being obstinate or anything else. We just have a disagreement. We think that, like anything else, standards have changed. Some things things have gotten more. Like I said, violation of court orders are treated more seriously than they were 6 years ago. That's the standard. The standard has increased. So that's where we're coming from. And I share that.
If I might, I just want to briefly say, using your example, a violation of a court order can be an extremely de minimis incident. And to look at a standard and say every single violation of a court order by a lawyer, whether it's a discovery related order or a scheduling order or some other procedural order, is going to require actual suspension, I can guarantee you there are probably 0 judges on the state bar court, if that's all you have, who are going to say, if this is a lawyer who's been in practice for 15, 20 years, sterling record, does community service, isolated issue, no client harm, no harm to the administration of justice, that lawyer is not going to get actual suspension. They're not. And so why waste the state bar's resources, relying entirely on the standard, when I think it's a guideline, but when you use the word standard, you're using it as if it's a mandatory floor, and it is not, nor should it be.
Right, but it is the presumed sanction. So we're going to start there, and it's not that we can't work our way down, but I think as Anon and other folks have described from our office, in these early stages, if we don't have all of the mitigation, all of the facts from the respondent, we're going to go forward according to the standards, according to the case law. That's our job. So that's how we proceed. But again, our starting point is the standard. That is what we're told by the Supreme Court. We do supplement it with case law, and then we look at aggravating and mitigating circumstances. And that's the analysis that we undertake. And we can disagree in a given case, but that's just outlining to you, how we proceed with our analysis when we approach a case.
Okay, so thank you, Rachel. And Ellen, with respect to standards, anything else you'd like to say?
From my perspective, no, I'm finished with my presentation unless anybody has any comments.
Yeah, that was meant for Ellen.
Oh,
Ellen,
sorry.
Comments?
Nothing that I think would be fruitful at this moment.
Okay, good. And this is going to be a continuing discussion, so we don't need to finish it all right now. Okay, with that, let's turn to Judge Wang, please.
Okay, my turn. Thank you, Rachel. I'm going to segue a little bit only because that was kind of the last topic. And I want people to bear this in mind. So the standards were set in the historical fashion that Rachel explained, and the difference between how law moves in the state bar courts very different from courts of record. You have constant litigation in Superior Court where legislation goes back and forth between the Court of Appeal, Supreme Court, and the legislature because, you know, the first district will interpret, you know, search condition law differently from the second district. And so there's this constant back and forth, and then the legislature answers with new law. The law here is pretty rigid. So as a judge, my approach is to start with the standards because that's what we're supposed to do. And then I have discretion based on case law and based on the standard. So as a judge, I can't move the ball forward. I can look to the review department, and we've had a few recent cases that have been saying, yeah, we have to look at the mitigators under 1.7C. We cannot rigidly follow the standard. And I think everyone's talking around the case, but it's Martin of commingling. So there is movement, but just to let you folks know, I don't think we should be afraid to say we need to make movement here to be more effective. We need movement here to be more fair, because there isn't this constant natural movement that we see in Superior Court and with the law. So for example, if there are any changes, it does go through the board, but unlike, you know, the criminal justice reform where you have a DA association and a public defender association, you have victims' rights groups, there's stakeholders that are constantly lobbying the legislature. That's not really happening here. So if this commission does identify issues that make the court run better, make OCTC run better, I don't think we should be shy to explore that. So I'll just now segue into what I've been asked to talk about. So I've been asked to talk about the court's perspective in settlements, and Mr. Lear actually had me speak a little earlier. So some of that material I had already kind of covered. I do also want to encourage, though, circling back to the settlements, is I think it was Melanie who mentioned this in our first group meeting, which I hadn't heard about, is the abandonment of the 20-day meeting. So if Melanie can kind of give us more information about that. And the reason why I'm bringing this up is to facilitate a more effective ENEC. I'm not sure what efficiency study, what was discussed to cause OCTC to decide that the 20-day meeting wasn't effective. I don't know statistically if there's any stats in terms of settling cases with the 20-day meeting versus not. But I do want us to consider that. And again, I know we're working under these time pressures, but what is a 20-day meeting where the parties are engaging in a robust conversation before they get to the ENEC, perhaps that would make the ENEC work a little better. And in terms of what Defense Counsel wants in terms of their perspective at an ENEC, I think it's different from what OCTC is expecting. Anand was focusing on the direction the judges have under the ENEC rule, which is to give the judicial evaluation of the charges. I approach an ENEC with that in mind, but also with an eye towards early settlement. So I approach it as more global, and I think that's what Defense Counsel wants too, because they want a neutral settlement. So I do respectfully disagree with Anand in the court's role in an ENEC. With that in mind, it does work a little differently than a VSC. So at an ENEC, I feel I can give OCTC more direction in terms of whether or not I think the charges will land, and what I think is appropriate in terms of how this matter should settle. In a VSC in the settlement conference, at that point, I'm frankly more of a mediator at that point, because I think OCTC has made the charging decisions. So at that point, I'm trying to facilitate settlement. I'm mindful of my role not to coach either side, just as I won't, try to coach, respondent into what I think is a valid defense. I would not coach the prosecution and how to secure a prosecution. So that's why I do think my role is different. And that's why I do think it's very important to have both. So with that in mind, I hope the folks here think about whether or not there's a way of jumpstarting the ENEC with that 20-day meeting. And just to let people know who aren't doing this work, with the ENEC, I get the letter from OCTC, their position 3 days before the conference. Okay, so if the Respondents Council wants a robust hearing, 3 days is not enough in terms from the court's perspective to really do a deep dive into all the cases, especially when you have OCTC who's been investigating this for 2 years. So I had a recent ENEC where the OCTC was, they know this case in and out. So for me to now come in to try to guide that conversation, it's not realistic. That's why, Anand, I do ask in those types of situations for a second or a third ENEC, because I'm not effective unless I have more information. And Ellen, do you want to cut me off while I cut me off now since I'm rambling? Oops, did I freeze?
No.
Oh, okay. Ellen, did you want to jump in?
Thank you. Thank you very much. I just want to applaud and endorse what Judge Wang just said. I want to mention that when I was at the fairness meeting on Tuesday, one of the presentations by the State Bar was the percentage of respondents who are unrepresented in disciplinary cases. And even I was surprised at how low the level is. And I fear that, particularly with the points that Judge Wang just made, if you're an unrepresented respondent and you go into an ENEC, you have no idea what you're supposed to present. And in order for an ENEC to be effective, the defense bar now knows we need to come in almost as well prepared as we will be at trial. We need to have mitigation. We need to be able to paint the picture. If there are disputes in the evidence, we need to have perhaps declaratory evidence from witnesses, because the ENEC is the last chance to resolve the case before a notice of disciplinary charges is filed. I also want to again share some of the observations of other members of the defense bar. There is a very wide sense that there's overcharging and duplicative charging, and that when you go into an ENEC, many times the only thing that the Office of the Chief Trial Counsel presents is a draft notice of disciplinary charges. So it's not the type of presentation that we are making to the judge, which is more general. I mean, speaking for those practitioners who I know, it's more of a substantive presentation corroborated by documents, for example. And that's why the defense bar also wants there to be more than one ENEC. My recommendation to this commission is that we look at and completely revise the ENEC process. When I was at the State Bar in the 70s, the system was more like a criminal prosecution system, and we actually had preliminary hearings. And so before the notice of disciplinary charges was prepared, it was a volunteer at that point, but it was a state bar judicial officer who vetted and approved the allegations. And in a sense, I mean, to me, that's what the ENEC process should now include. As I said earlier, at least my experience in the recent 5 to 10 years has been that if I take a case to trial, and even if I end up settling it, it's very rare that the respondent is actually called upon to stipulate to all of the charged counts. Typically, some of those counts are going to be dismissed. And so it would be much more efficient for everyone, including to allow respondents to be able to find and afford legal counsel, if we could drill down before the notice of disciplinary charges is filed and have a more accurate assertion of the violations. And I feel very strongly that this is something that we need to do, a deeper dive into, or establish another subcommittee, because it's something that the defense bar is pretty much up in arms about.
Okay, thank you.
Melanie has her hand up.
Yeah.
Okay.
So a couple things, Judge Wang, to your point about the 20-day letter or meeting. I want to say it was probably around 2012, 2013-ish that the office stopped engaging in that process. It was an internal policy that we had, but I mean, it was a practice, longstanding practice in the office. I think the challenge, frankly, when it comes to that process, as well as the ENEC process, is we don't really have good data to tell us really how effective are these processes. I mean, I know we all have feelings. OCTC feels like it's relatively ineffective. I hear from ADDC that they think it's a really effective process. But again, those are just feelings that we have. And we are in the process of trying to collect some of the data. I think one of the interesting pieces is something that I've heard here today is the idea of, what was OCTC's settlement position? What was the judge's settlement position? And what was the respondents' counsel's settlement position? Because then we can sort of see, especially if that case ends up going to trial, how close were all of us. I think that would be important information, but it's a process to get that information. And back in the 20-day meeting days, that there was no way to actually collect that kind of data. And much like what we see with the ENEC process, and it's not that OCTC completely sees it as ineffective, but I think we are always working under the burden and the pressure of the time standards. And that was one of the issues when it came to the 20-day, is it just felt like another obstacle that didn't necessarily feel terribly effective to us. I can imagine that it might feel more effective to a respondent or respondent's counsel. But I think it's good to have these discussions and to have further discussions about how we can revamp the ENEC process. But I think it has to be with the backdrop and understanding that we have to do something about the time standards, because OCTC cannot be having multiple ENECs over months with no public filings if it's really a public protection issue, and with the time ticking on the 180 days that the auditor is later going to scrutinize us over. So we have to think about all of that within those structures. But I think it's well worth more conversation.
Okay, so here's what I said to everybody earlier, and I'm going to hold to it, which is 3 o'clock shutdown today, which leaves a couple of topics. And I want to talk a little bit about homework. The big topic that I don't even want to start today is moral turpitude. And you will all be probably surprised that the moral turpitude statute, which is Business and Professions Code section 6106, I think is 2 lines. It's pretty simple, and it's dishonesty, corrupt practices, and gross negligence. And obviously I'm paraphrasing, but that's the essence of it. And yet it has such profound consequence. And I'm just going to tee up a couple of things for you. So we have talked a lot about standards, and Rachel did a nice job with that, and Ellen did a nice job with that. But the way that moral turpitude is evaluated generally is that if moral turpitude is proven, then you go to the standards, and the standards dictate the discipline. And then defense counsel comes in and says, well, not so fast. You can't apply the standards in talismanic fashion. You have to look at the mitigating factors. And so the homework is in part this: look at 6106, Business and Professions Code 6106. It'll take you 30 seconds, but it'll inform you as to a really profound topic. Secondly, I'm going to ask Justin, or work with Justin, in forwarding to you all the Yee case, Y-E-E. And I don't think it's long, but that's a case that I haven't read in a while, but I'm pretty sure it's a moral turpitude 6106 violation that ultimately was a public reproval. So you can see that there's a way to deviate, even with a finding of moral turpitude, from an actual suspension. And it's interesting. It generally involved I believe a female attorney who did not accurately report her MCLE credit to the state bar. And so it's in the spectrum of bad things. We would probably all agree that that's on the lower end, and the court agreed. It's a review department decision, and it's a favorite of defense counsel, insofar as arguing at least that moral turpitude doesn't always mean actual suspension. So I'm going to ask you to look at that before the moral turpitude discussion next time, because it will inform you that, one, indeed, the standards are not applied in talismanic fashion. It will be an example of a lower end discipline for a case in which there was a moral turpitude finding. And of course, we could come up with 500 cases where an attorney engaged in a really bad act that involved moral turpitude and the attorney was disbarred. I mean, you can generally make that assumption that many of those cases are out there. And it may be that Melanie reaches out to me and says, well, if you're going to have everyone read the Yee case, you should also have them read X case of really bad conduct. Fine. We can do that just to balance everything out. But I think Yee will be interesting to you all in the context of moral turpitude. The other thing that I want you to all think about is this: that one of the reasons that the moral turpitude discussion is so interesting is because it can be a disqualifying factor in a request for a respondent to be in the alternative discipline program. Okay, when it involves something other than gross negligence, or if it involves a corrupt or dishonest practice in the course of practicing law, it can be disqualifying. And it's a really interesting discussion that we should talk about, and that'll be for next time. Then, as another part of your homework is this: many of you heard about things that you had no clue about until today, and so no doubt in the quiet of your studies, you will think about things that maybe didn't make sense or that you'd like to develop further. So if you would be so kind as to email Justin with any questions that you have, because what I hope is that today's robust colloquy causes questions, causes you to think, causes you to figure out how the discipline system can be more effective. And you may not be thinking about that in the moment, but I bet that as you're driving along somewhere, you're going to think, well, geez, I have maybe a solution, or I have a question, I have an approach. And so ping those to Justin so that we can incorporate that into the agenda, so we can get a better idea of what you're all thinking about, so we can be effective and solution oriented. Because at the end of the day, this is all about solutions. And you heard a little bit about potential solutions today. I don't think we were heavy on that. We were a lot heavier on explaining how the system works, and then taking respective positions of where the system is not working, and obviously having differing opinions on that, which is expected and which I think is healthy, and also really nice to have the court's point of view with respect to what the court observes. So those are my my general comments. Does anyone want to add to that? Maybe another suggested homework assignment? If so, this is the time to throw it out.
Chairman, if I could share, I've been taking notes throughout the day, and I have some topics that at least one member of the subcommittee have raised. But since we have to go to recommendations in a couple months and try and move that forward and focus staff, if I could share the things that have been brought up by different subcommittee members and then get some direction on places that you would like to see brought back to the committee that we could focus on, would that be acceptable?
Very helpful, yes.
Okay, let me share my screen. So if you can see my screen, these are just things that came up during the discussion in the first part of the discussion. The recidivism of lawyers through ethics school, that's some, we could maybe potentially do some investigation on that. There was some talk about the case prioritization and whether or not we wanted to dig down deeper into that. The research on initial charge versus charge at trial versus ultimate discipline imposed, the backlog as a metric, or if there's something more effective that we could measure, and then the standardization versus discretion in OCTC. And then Judge Wang talked about maybe increased judicial discretion. Then progressive discipline, I think this is being touched in fairness. We really talked about kind of progressive discipline, so I wouldn't necessarily think effectiveness needs to address this because I think it is being addressed in the fairness subcommittee. And then there was talks about limiting to one ENEC versus ENECs for criminal conviction referrals and a lot of ESCs. So now what I'm asking the subcommittee is there consensus around some of these topics that you would like us to bring back? Because most of these were brought up by one, maybe two members, but the subcommittee is made of multiple members. So I don't know, I'm throwing it out knowing that we have 6 minutes left, hoping that we can get some direction for staff.
My suggestion on the ENECs would be just sort of grouping the issue of ENEC sort of together. Of course, OCTC's position would be to limit, but I think really the broader issue is, taking a look at the ENEC process and ways that maybe it could or should be changed.
And Justin, I'd like to add something that's a curiosity to me, and that is generally with respect to cases that settle. Is there a statistic that breaks out cases that settle where respondents are represented by counsel versus when respondents are not represented by counsel, and then further breaking that out to ENECs versus voluntary settlement companies? I don't know if those statistics are kept, but they would be informative.
Justin, I like all these topics. I don't see any that I would say we shouldn't consider them unless it's something that the Fairness Committee, is taking on. They're all important.
Right, progressive discipline sounds like a Fairness Committee, but what I mentioned, Ellen, earlier is that there's an inevitable overlap between fairness and effectiveness. And that will just continue, and they'll talk about some of our topics as we'll talk about some of their topics. So
I thought that increased judicial discretion has come up last time and this time. I'm very sympathetic to Judge Wang's wish list and her suggestion last time about dealing with attorneys who are aging and having alternatives to being having the whole case dragged out. Given, up the opportunity for voluntary resignation. And then this time, that discretion, having discretion over 1.8. So judicial discretion here seems to be, I applied to, it was more than just a one shot point. I think that there's, I didn't realize that there is how much the judge is involved and sometimes has her evaluations contested.
Okay.
Justin,
So,
can I add or
Yes.
can I add to Eloise? That's what I wanted to add to the list because that I meant to get to resignation with charges pending. I think that is, if not here, then in fairness, I think it needs to be something that we take a look at.
Yeah, and I think that was in the discussion of about, how we're dealing with aging and aging attorneys. I mean, we're all aging, but some age differently. Not everybody's Ruth Bader Ginsburg. How can we sympathetically, look at factors that, some people break their legs. We don't blame them for breaking their leg. Some people's minds start to decompose or grow less competent in higher functioning areas. What is the proper view of that within the state bar disciplinary system?
I wanted to chime in. There's an email that I received that I don't think the rest of you received, and maybe in my role as chairman. And it looks like it was prepared by staff, and it had 4 questions on the last topic that we were discussing. And I think we touched on all of them generally, but I think that we could probably follow through on each one of them in our next session, because this idea of factors impacting case settlement is slated both for today's session and for July. And the questions are, what is the current process for settling cases? And I think we handled the ENEC portion of that pretty well. We have not talked about the voluntary settlement conference process, which I think we should add to the next agenda. Then my question, what percentage of cases settle? And then they broke that out into some subsets. Then should more cases settle? I'd be surprised if anyone in our group said no. And then I think the most important question, and probably one that drives the entire basis for our subcommittee, which is what could be done to increase settlement rates? And I think that last question is the one I'd ask you all to keep in mind, because to a degree, that's what effectiveness should be focused on. How do we increase settlement rates? So with that, I'll work with Justin in summarize.
Jenna Jones has her hand up.
Oh, sorry, go ahead.
Jenna, you're off mute, but we can't hear you, or I can't hear you. I don't know if anybody else can. Is anybody else hearing Jenna? Okay. If you can get your microphone fixed, Jenna, we'll gladly take your comment. Melanie, you had your hand up.
Yeah, so sort of thinking about adding to the list, when I hear Ed, you mentioned about increasing settlement rates, I think that's a good thing, but I think it sort of goes to something else that we talked about earlier. And if we're talking about effectiveness, we really maybe should be thinking about some of the more proactive things that we can be doing so that we're not impacting the discipline system at all, quite frankly.
Can you elaborate? I didn't really follow.
Sure. I mean, just what are the early interventions, for example? What are the things that we could be doing so that people don't find themselves in the discipline system, or certainly so far in the discipline system that we're talking about settlement?
Okay, fair. Okay, we can add that too. Okay, so that is all I have. I will work with Justin in putting together the agenda for the next meeting. If you have thoughts or ideas, then please reach out to Justin so that we can get our arms around this and have a tight agenda. Justin, I appreciate the work that you and Lisa did in terms of processing the agenda for this meeting. I thought it went well. I thought we covered a lot of topics really well. I think all the speakers did an amazing job. Thank you for that. Thank you for everybody's input. And with that, have a great weekend, and we will see you in July. Bye, everybody.